The purpose of this presentation is to provide a detailed explanation of the allegations related to the Wilgraven, Snell, and Wilmer investigation. As a high-level preview, in 2006, our victim, Wilgraven, was the CEO and significant majority owner of a steel building company by the name of Arizona Building Systems, or ABS. He alleges that in January 2006, ABS General Counsel Daniel Esposito and ABS minority owner Deborah Debris conspired with three attorneys from Snell and Wilmer, Jim Sinicki, Mark Orr, and Bill Kasten, to make changes to corporate documents without his knowledge to force him out of ABS and give Deborah Debris and Daniel Esposito ownership and control over the company. Before I get into details, I should make clear that there's no one piece of evidence that proves this case. It's a series of small data points that individually don't mean very much, but collectively in the context of all the other data points, they paint a very incriminating picture. So it's very important to pay attention to the small details, and I'll try to highlight those details throughout the presentation. I think some background is important to understand where this investigation fits into all the other 6 investigations we have related to Wilgraven. Mr. Graven first walked into the Attorney General's office in November of 2011. During that first meeting, he made several allegations against his executive team at Arizona Building Systems. It wasn't until June of 2012 that we actually opened an investigation, and during our initial review of the evidence, it was clear that based upon the large volume of alleged criminal conduct by more than 10 different suspects, we needed to break the investigation into several smaller investigations. The first case we opened was against the Director of Information Technology, Greg Smolens. We chose Greg Smolens first because we recognized that most of the allegations could be supported by corporate emails, and we needed access to company computers and other digital evidence. On July 8, 2013, we charged Greg Smolens with 18 different felonies. He subsequently pled guilty and is now cooperating. The next case we opened is titled Expedition because it was into allegations that several members of the ABS executive team used corporate money without authorization to buy a 2006 Ford Expedition. That investigation revealed a lot of other criminal conduct, and we just never changed the name of the investigation to reflect the increased scope. On April 28, 2014, we indicted 6 members of the ABS executive team as a result of the Expedition investigation. Michael Groh was the chief financial officer. Deborah Debris, as I mentioned, was a 9.9% minority owner of ABS, and Pam Johnson was the controller. Michael Groh and Deborah Debris both pled guilty and are now cooperating. Pam Johnson's allegations are pending trial. The other 3 people we indicted as a result of the Expedition investigation were Mike Martin, Daniel Esposito, and Thaddeus Sabarnia. Mike Martin was hired as a senior vice president of operations, but was promoted to president in March of 2006. Daniel Esposito, as I mentioned, was the general counsel for Wilgraven's companies, and according to Wilgraven, was his personal attorney and friend. And Thaddeus Sabarnia was a senior vice president of operations. Thaddeus Sabarnia subsequently pled guilty and was sentenced to probation, and the charges against Esposito and Martin are pending trial. The next case we opened is titled Emery Rubble, into allegations that ABS President Mike Martin gave about $87,000 worth of construction rubble to his friend and coworker Daniel Wallner. This construction rubble was already under contract to be sold to a California company by the name of Emery Materials, but prior to Emery Materials taking delivery of the rubble, Michael Martin gave that same rubble to Daniel Wallner, and then he sold it to Emery Materials for about $62,000 and kept the proceeds. This investigation is currently ongoing. The next case we opened was into allegations that another chief financial officer by the name of Doug Epley committed forgery, theft, and computer tampering while working at ABS. On December 23, 2013, we charged him with multiple felonies. He subsequently pled guilty and is now also cooperating. The next case we opened is titled City of Victorville, into allegations that several officials from the City of Victorville in California grossly misrepresented the state of the city's finances, and then when a large construction project at the Victorville airport stalled due to lack of funding, the same city officials conspired with several members of Wilgraven's executive team to forge a document which resulted in $8.5 million in losses to another Wilgraven company, CBS Aviation Development, LLC. This investigation is also ongoing. The next case we opened is titled Snell and Wilmer, which is the focus of this presentation. And before going into the details on the Snell and Wilmer investigation, on August 3rd, 2015, we did charge Mike Martin and Daniel Esposito with several additional felonies as a result of the first case we opened back in June of 2012. The new charges are related to allegations that Mike Martin and Daniel Esposito worked with several members of the ABS executive team to form competing companies and then used ABS intellectual property, personnel, and other resources to pursue millions of dollars worth of ABS projects and leads for the benefit of their competing companies. And they did this while collecting an ABS paycheck and purporting to Will Graven that they remained loyal employees. Daniel Esposito was also charged with the allegations related to the Snell and Wilmer investigation. Deborah Debris entered into a plea agreement with the state and is now cooperating, but the Snell and Wilmer attorneys, Jim Sinicki, Mark Orr, and Bill Caston, have not yet been charged. So that's a quick summary of all the investigations related to victim Will Graven. Now we'll turn our attention to the Snell and Wilmer investigation. Understanding the allegations related to Snell and Wilmer depends largely on an understanding of the relationships between Will Graven, Snell and Wilmer, and all of Will Graven's companies. And I'm going to try to convey the nature, details, and scope of those relationships by first talking about Will Graven's engagement with Arizona Building Systems. It's a little historical, but it's important to understand how Will Graven came to be in control of ABS. And then I'm going to talk about how and why Will Graven engaged Snell and Wilmer and the nature and scope of that engagement. And then I'm going to talk about the friendships that formed between Snell and Wilmer attorneys and Will Graven's general counsel, Daniel Esposito. This is important because Will Graven believes, and the evidence strongly supports, that a close personal friendship between Daniel Esposito and Snell and Wilmer attorney Mark Orr clouded Mark Orr's judgment when it came to his fiduciary duty to Will Graven and his companies. The investigation also confirmed a long-time professional relationship between Snell and Wilmer attorney Jim Sinicki and ABS minority owner Deborah Debris, but it's unclear at this point what impact, if any, that relationship had on Jim Sinicki's decisions at the time. Then in late 2005 and early 2006, Daniel Esposito and Deborah Debris engaged in a conspiracy to take over ABS. And I'll go over that in great detail and talk about the role that Snell and Wilmer played in that conspiracy. And then in about June of 2007, all of Will Graven's companies went out of business. And that wasn't something that happened overnight. It happened over the course of several months. In the wake of his companies going out of business, Will Graven discovered what he calls red flag emails. In chronological order, the red flag emails are 1, 2, 3, and 4. However, Will Graven discovered the third and fourth email in that chain first in 2007, and then he didn't discover the first and second email, which completed that thread of communication, until 2011. As a result of those red flag emails, Will Graven filed a civil lawsuit against Snell and Wilmer. And we'll go into some detail about what that lawsuit included and how Snell and Wilmer responded to that lawsuit. But it's very important to understand now that the lawsuit filed in 2011 was limited to the red flag emails. It had nothing to do with the conspiracy to take over ABS. In fact, when Will Graven filed this lawsuit against Snell and Wilmer, he didn't even know about the conspiracy to take over ABS. That wasn't discovered until about April of 2014, as Will Graven and investigators were reviewing thousands of emails and other documents that were collected pursuant to the other investigations. And then after discovering that conspiracy, the Attorney General's office opened the Snell and Wilmer investigation. So we're going to start with the engagement with Arizona Building Systems, and we'll revisit this slide throughout the presentation as it provides a roadmap of what we're going to discuss and in what order. To begin with, Arizona Building Systems was a steel metal building company that did business primarily in Arizona. Sales were struggling between 2001 and 2004, so as a result, then owner of Arizona Building Systems, Deborah Debris, tried to sell the company. The two silhouettes shown next to Deborah Debris are minority shareholders who aren't named in this presentation because very soon they'll be bought out and will become irrelevant. On January 8, 2005, Will Graven and Deborah Debris signed this consulting and option agreement that gave Will Graven the option to purchase ABS for $350,000. That began a period of due diligence during which Will Graven discovered that ABS was in much worse shape than Deborah Debris had represented, so Will Graven decided not to exercise his option and to walk away from ABS. At the time, Deborah Debris was concerned that an ABS failure could drag her into personal bankruptcy, so she asked Will Graven to stay with the company long enough for her to separate her personal finances and obligations from that of the company's, and if he agreed, she would walk away from ABS and he could have the entire company for essentially nothing. So on February 18th, 2005, Wilgraven wrote this amendment to the original consulting and option agreement. But instead of Wilgraven buying 100% of the company for essentially nothing, he wrote this amendment to allow Deborah Debris to retain 9.9% ownership. He did this because for the previous several months, Deborah Debris had been receiving bi-monthly draws of $3,200, and the company had been paying for her leased vehicle, gas, and other expenses. Wilgraven believed these payments to Deborah Debris were bleeding the company of much-needed capital, so he wanted ABS to stop making these payments, and in exchange, he would give her 9.9% ownership. Deborah Debris said she wasn't interested in any ownership and instead wanted to remain an employee, continue taking her bi-monthly draws, and have the company continue to pay for her vehicle, gas, and other expenses. Because Wilgraven was serious about minimizing ABS costs, he wrote this second proposed amendment and added a specific bullet to address the very concern that Deborah Debris had articulated about separating her personal finances and obligations from that of the company's. Wilgraven was doing this to incentivize her to accept the 9.9% ownership instead of remain an employee. But Deborah Debris again refused and said she wanted to remain an employee if and when Wilgraven exercised his option. So on the same day, Wilgraven wrote this third revision to the consulting and option agreement. This gave him the right to purchase the entire company for $1, but would also obligate him to sign Deborah Debris' employment agreement with Arizona Building Systems. Of course, under this scenario, Deborah Debris was not entitled to 9.9% ownership. And then for the next several months, Wilgraven continued his due diligence on the company. He was trying to generate new business and turn the company around. And then on May 9th, 2005, he worked with a California-based consultant to start California Building Systems, or CBS. When Wilgraven started CBS, Deborah Debris had no ownership or role in the company whatsoever, and CBS was, in fact, an entirely separate legal entity from ABS. Wilgraven had 100% control over the company, and he envisioned using it to pursue projects in California while using ABS to pursue projects in Arizona. So that's a quick summary of how Wilgraven began his engagement with Arizona Building Systems. Now we're going to talk about Wilgraven's engagement with Snell and Wilmer. This part of the presentation is a bit tedious, but it's very important to understand the genesis and history of the engagement between Snell and Wilmer and Wilgraven, so that later, when Snell and Wilmer claims the relationship with Wilgraven is something contrary to the evidence, we'll be able to recognize that contradiction. As a preview, during this part of the presentation, I'm going to present evidence that shows for 4 to 5 months between June and December of 2005, Snell and Wilmer represented Wilgraven and several of his companies on a variety of personal and corporate legal matters. Snell and Wilmer invoiced Wilgraven as president of ABS for more than $130,000 in legal fees, and consequently, Snell and Wilmer developed a fiduciary duty to act in Wilgraven's best interest and to notify him immediately of any conflicts. Then in December of 2005, Daniel Esposito directs Snell and Wilmer to make changes to the ABS shareholders agreement to give Daniel Esposito and Deborah Debris control over the company. These changes were against Wilgraven's interests, and the evidence will show that Snell and Wilmer knew the changes were against his interests, but rather than notify Wilgraven immediately of what Daniel Esposito and Deborah Debris were doing, Snell and Wilmer concealed the activity from Wilgraven by not mentioning it during subsequent face-to-face meetings and email communications. And despite operating for 4 to 5 months without any engagement letters, they devised a 6-step plan to work with and through Daniel Esposito to write new engagement letters that falsely rewrote history and erased their fiduciary duty. Snell and Wilmer then made the changes to the shareholders agreement, which were against Wilgraven's interest, and then invoiced Wilgraven at ABS for the work. They further concealed the activity from Wilgraven by removing revealing language from a draft billing statement, and then they sent this one billing statement to Daniel Esposito while sending all other billing statements to Wilgraven. And then they continued to conceal the activity from Wilgraven by refusing to give him copies of his own client files. And we'll also see much later, near the end of the presentation, that Snell and Wilmer hampered any future investigation by failing to preserve several key documents. And all of these allegations will be supported by the documentary evidence presented during this presentation. So here's a simple visual representation of who owned what in May of 2005. And throughout this presentation, this organizational chart is going to grow to include more than 30 companies. On the left, you have Deborah Debris, who is the majority owner of ABS. There are 2 minority shareholders who will be bought out momentarily. And Will Graven was the owner in waiting because he had not yet exercised his option to buy the company. And on the right, we have Will Graven as the sole owner with 100% control over CBS. At the time, Will Graven didn't have an attorney, so he asked Deborah Debris if she knew anyone who could help him with a variety of personal and corporate legal matters. Deborah Debris knew Jim Snicki of Snell and Wilmer because they were both members of the CFMA and for the previous few years had seen each other professionally at monthly meetings, occasional golf outings, year-end award ceremonies, and other CFMA-related events. Deborah Debris referred Will Graven to Jim Snicki, and after a face-to-face meeting, Will Graven decided to hire Jim Snicki and Snell and Wilmer. Both Will Graven and Deborah Debris, even today, say the reason Will Graven engaged Snell and Wilmer was because it was a large, well-recognized and trusted law firm, and because they had expertise in Native American law, which was an area into which Will Graven wanted to expand his business development efforts. And I should also say that during subsequent interviews with Deborah Debris, she matter-of-factly referred to Snell and Wilmer as Will's attorney, not hers, because she was represented by the law firm Deaconson, McDonald, Yetwin, and Lacey. There was just no doubt in her mind that Snell and Wilmer represented Will Graven, which will become very important as this presentation moves forward. On or about June 16, 2005, Will Graven and ABS needed legal representation on a civil lawsuit between ABS and a company called eCrete. The nature of the lawsuit isn't relevant to the investigation, just the fact that Snell and Wilmer represented ABS on this matter is what's important. On the screen is a typical Snell and Wilmer invoice. At the time, Snell and Wilmer addressed the invoices to Arizona Building Systems to the attention of Will Graven, president. Snell and Wilmer's client ID for ABS was 48775, and the letters JJS are the initials for Jim Snicki. The matter field includes the ABS client ID and a unique 4-digit number joined by a period, Jim Snicki's initials, and then a descriptive name for the matter, in this case, eCrete. Along the column on the left side of the invoice are the initials for the attorneys and support staff who provided billable hours with a description of the work done during those hours to the right. And then at the end of the invoice, there's a list that includes the initials and names of the attorneys and paraprofessionals, their hours, their rates, and the amounts they had billed to the matter during the billing period. So this is a typical invoice, and we'll be reviewing a lot of these invoices throughout the presentation. What's important about this first matter is that Arizona Building Systems was the client. So it's appropriately using the client ID for Arizona Building Systems. Another thing that's notable about this matter is that there's no engagement letter. Investigators later obtained copies of all of Snell and Wilmer's internal client files for Will Graven and his companies, and could not find any engagement letter for this matter. And the fact that there's no engagement letter will become important later in the presentation. In early 2005, Will Graven was driving in the valley south of Phoenix and noticed an underdeveloped airport known as Memorial Airfield. He became interested in forming some new companies entirely separate from ABS to develop the 1,500 acres of land that made up the airport and the 11,000 acres of land that surrounded the airport. So he started to foster a relationship with the Gila River Indian community, and he also sought legal advice from Jim Snicki and Snell and Wilmer on the mechanics of that development. And this will be reflected shortly in emails and within Snell and Wilmer invoices. Also in early 2005, Will Graven started pursuing development projects in California using California Building Systems and several other companies he hadn't yet formed. One was in Indio, California, one was in Victorville, California, and one was in Mojave, California. Again, Will Graven needed legal advice on the mechanics of these projects surrounding the build-to-suit to lease agreements with the various customers, and he sought that legal advice from Jim Snicki and Snell and Wilmer. This legal advice will also be reflected in future billings as well as in the email on the next slide. On July 15, 2005, Jim Snicki sent this email to Will Graven. In the email, Jim Snicki referred to a telephone conversation he had with Will Graven that day. Jim Snicky also wrote that he had done conflict checks on the 2 California and 5 Arizona airport leases your companies intend to enter into. What's important to point out here is that he writes your companies, plural. So even Jim Snicky at this point recognized it isn't just ABS that he's representing. He's giving legal advice to additional Will Graven companies. And these references to 2 California and 5 Arizona airport leases are consistent with the projects I just described on the previous slides. Jim Snicky referred Will Graven to Charlie Hurst, who was an attorney out of the Snell and Wilmer office in Orange County, California, and he writes that Charlie has previous experience dealing with Victorville, which again is consistent with one of the California projects I described in the previous slide. He also refers Will Graven to Jay Wiley, a real estate partner in the Phoenix office to handle the Arizona leases. Finally, Jim Snicky writes that he's going to open up 2 new matters, one for the California leases and one for the Arizona leases. Here's a copy of an invoice that corresponds to the first of the 2 new matters. You can see it's matter number 48775-0002, titled ABS Aviation AZ Airport. If you look at the descriptions of the work done on this matter, you can see it has everything to do with the Gila River project, which Will Graven planned to pursue with companies entirely separate from Arizona Building Systems. In fact, the first thing Will Graven did to advance the Gila River project was acquire a company called Bygert, which was later renamed Far West Aviation. Bygert owned a hangar at the Memorial Airfield, about 10,000 square foot hangar with about 3,000 square feet of office space. Will Graven bought Bygert so he'd have control over that lease, which was the very first step in what would become a very ambitious Gila River project. So this work had nothing to do with Arizona Building Systems. All this work was for Will Graven personally and for the companies Will Graven had not yet acquired or formed to pursue the Gila River project. Here's a copy of the billing statement for the second of the 2 new matters that Jim Snicky was going to open. You can see it's matter number 3, titled California Building, California Airport. And if you look at the description of the activity, it has everything to do with California projects. Southern California Logistics Airport is the Victorville Airport. John Roberts was the city manager for the city of Victorville. Here's a direct reference to the city of Victorville. All of this work has to do with California Building Systems and other companies Will Graven had not yet formed. It had nothing to do with Arizona Building Systems. And what's also remarkable is now we've got 3 separate matters and still no engagement letters. Will Graven told me at the time he didn't notice that there wasn't an engagement letter. He didn't pay attention to client IDs or matter numbers. He just trusted that Snell and Wilmer, a large, well-respected law firm, was managing the engagements properly. And while it may have started with Snell and Wilmer representing Arizona Building Systems on its civil dispute with ECREAT, at this point, by this 3rd matter, Snell and Wilmer's engagement with Will Graven had expanded. They were no longer just representing Arizona Building Systems, they were representing California Building Systems, and they were representing Will Graven personally on projects he hadn't yet started and on companies he hadn't yet formed. On or about July 15, 2005, Snell and Wilmer opened a 4th matter titled Construction Contracts Review. Will Graven recalls speaking with Deborah Debris about engaging Snell and Wilmer and asking them to review some of the document templates that ABS had been using. And it looks like, based on the descriptions in this billing statement, that that's exactly the kind of work that's taking place here. Investigators did find a copy of this engagement letter dated July 6, 2005, titled Limited Representation of ABS Regarding Review of Construction Contracts. This is consistent with Matter 4, so this is the first engagement letter we found among Snell and Wilmer's internal client files for Will Graven and his companies. And on the second page of this engagement letter, it indicates that if a conflict were to arise between Arizona Building Systems or those of any other client, that Snell and Wilmer would apprise Will Graven of that fact, but reserve the right to represent the interests of the other client. The text reads, apprise you, but the letter is addressed to Will Graven. So Snell and Wilmer is telling Will Graven that if they identify a conflict, they will apprise him of that fact. What's unusual about this particular engagement letter is that it's not signed by anyone. And when I talked to Will Graven about this engagement letter, he said he had a vague memory of an engagement letter very early in his relationship with Snell and Wilmer, but he didn't recall that it was ever expanded to reflect the increased scope of his engagement. So this might be the engagement letter that Will Graven recalled, but investigators have not been able to find a signed copy. So continuing on our timeline, on July 25th, 2005, Will Graven formed another company in California called CBS Aviation Development LLC, or just CBS Aviation. And just like California Building Systems, this company was entirely separate from Arizona Building Systems and entirely separate from Deborah Debris. And when it was first formed, Will Graven had 100% control over this company. On August 1st, 2005, Will Graven engaged Snell & Wilmer to help ABS pursue an opportunity with Hoffman General Contracting. So here we have a fifth matter titled Hoffman General Contracting. And just like the previous four matters, it too uses the client ID for ABS, 48775. And again on August 1st, 2005, here is the sixth matter titled Construction Legal Advice. I asked Will Graven about this, and he's not sure who the client was on this particular matter. It could have been any one of his companies, but based on the reference to voluntary departure, it looks like it had something to do with an immigration matter. In any case, by this time, Snell & Wilmer had opened 6 separate matters, at least 2 of which were for entities entirely separate from ABS, yet Snell & Wilmer used the client number for ABS on all 6 matters. And even though there were 6 separate matters, Snell & Wilmer was comfortable at the time not requiring any signed engagement letters. Around this time, Will Graven also started speaking with Jim Snicki about forming a personal holding company because, as you can see, he had a small network of companies, and this network of companies was continuing to grow. So Will Graven recognized he was going to need legal advice, so he started speaking to Jim Snicki and getting that legal advice. And this too will be reflected shortly in the billing. As the engagement between Will Graven and Snell & Wilmer continued to evolve, the project in Victorville, California really started to take off. Will Graven was negotiating an agreement to design and build several large commercial airplane hangars at the Victorville airport. It was work so voluminous that it required a $200 million line of credit, and since both CBS and CBS Aviation used a lot of ABS resources, increased revenue from Victorville meant increased revenue for ABS. So Deborah Debris approached Will Graven and said, "Hey, in the wake of this increased revenue in Victorville, can we please revisit the idea of giving me 9.9% of the company, because now there's an upside, where before the company was teetering on bankruptcy?" Well, by this time, Will Graven had grown frustrated with Deborah Debris because for several months she continued to draw out of the company $3,200 every 2 weeks, and Will Graven believed this was bleeding the company of much-needed capital. But even though he was frustrated with Deborah Debris, Will Graven said he would consider it. On or about August 24, 2005, Will Graven decided to engage Snell & Wilmer to represent ABS on a lawsuit with Sawyer Aircraft. So Snell & Wilmer opened up a 7th matter titled Sawyer Aircraft Charter, and just like the previous matters, there was no engagement letter. So now we have 7 separate matters, all of them using the client ID for ABS and no signed engagement letters. On September 16, 2005, Jim Snicki sent this email to another attorney at Snell & Wilmer, Joshua Grable. The point of this email is to demonstrate that Jim Snicki knew at the time that even though Will Graven had not yet exercised his option, he was the de facto CEO and was making decisions on behalf of the company. In the email, Jim Snicki writes regarding a possible settlement with ECREAT, "We are going to have to get Will's blessing on it before we agree to anything." And with regard to Sawyer Aviation, he writes, "I have a call into Will regarding what to counter at." So this email is consistent with Jim Snicki knowing that while Deborah Debris was technically the owner of ABS because Will Graven had not yet exercised his option, he was in fact making decisions on behalf of the company. On September 19, 2005, Will Graven hired Daniel Esposito as the general counsel for Arizona Building Systems and Will Graven's growing network of companies. When he was hired, Daniel Esposito had very limited experience and wasn't even bar certified in Arizona, so Will Graven had concerns relative to his performance. So Will Graven met with Jim Snicki to express his concerns. He said, "Look, this guy has limited experience. He's not even bar certified in Arizona, but he had so much enthusiasm and an eagerness to learn that I went ahead and hired him. So please keep a watchful eye on him and let me know if there are any issues related to his performance." According to Will Graven, Jim Snicki agreed. Will Graven also followed up with Joshua Grable, who, as I mentioned, was another attorney at Snell & Wilmer, and repeated his concerns about Daniel Esposito's lack of experience. And again, according to Will Graven, Joshua Grable said he had already spoken with Jim Snicki, understood Will Graven's concerns related to Daniel Esposito's lack of experience, and would notify Will Graven immediately if he developed any concerns related to his performance. It's also worth noting that during subsequent interviews with Deborah Debris, she too recalled that Wilgraven was concerned that Daniel Esposito wasn't bar certified in Arizona and that he had limited corporate experience. And she recalled that Wilgraven had expressed his concerns directly to Snell and Wilmer. So after Wilgraven hired Daniel Esposito, communication between Wilgraven and Jim Sinicki was expanded to include Daniel Esposito. In late September, early October of 2005, Wilgraven decided to let Deborah Debris retain 9.9% ownership in ABS in the event he exercised his option. Both Deborah Debris and Wilgraven agreed that she would countersign an earlier amendment to the consulting and option agreement, one that conveyed to her 9.9% ownership, and that the new signed amendment would supersede all previous amendments. And because Deborah Debris would receive 9.9% ownership, she agreed to terminate her ABS employment agreement. On October 5, 2005, Wilgraven finally exercised his options and purchased 90.1% of ABS. The two minority shareholders were bought out, so the resulting ownership was 9.9% for Deborah Debris and 90.1% for Wilgraven. In the spirit of fairness, and because Wilgraven said he used ABS as a springboard to form CBS and CBS Aviation, Wilgraven gave Deborah Debris 9.9% of these companies as well. They also reached a mutual agreement that Deborah Debris would transition out of the company, minimize her contact with ABS employees, and would be fully removed by December 31st, 2005. Wilgraven said, and during subsequent interviews, Deborah Debris later confirmed, that this was a polite and a mutual understanding. Deborah Debris wanted to get out of the construction business altogether and focus on her new company, and Wilgraven wanted to make it perfectly clear to employees that he was the new owner and CEO of ABS. Wilgraven also believed that Deborah Debris had taken ABS from being a profitable company to one teetering on bankruptcy, so he didn't value her input on day-to-day operations. He preferred instead that she remain a 9.9% silent minority owner. After Wilgraven exercised his option and hired Daniel Esposito, this is how his network of companies continued to evolve. We have a future holding company that Wilgraven was discussing with Jim Sinicki. We have these 4 other companies that were entirely separate legal entities, and we have Snell and Wilmer representing Wilgraven and DeConcini, McDonald, Yetwin, and Lacey representing Deborah Debris. Here's an email dated October 3, 2005 from ABS Vice President of Development Services Mark Stryker to Dan Esposito. According to the email, Wilgraven's looking for an attorney at Snell and Wilmer who has a lot of experience working on Indian reservations. The reason Wilgraven needed such an attorney is because he was still planning to form new companies to pursue the Gila River Project, which is the project I mentioned earlier in the South Valley with the Gila River Indian community. And on or about October 11, 2005, just a week after that email, Jim Sinicki opened an 8th matter titled Gila River Project Airport Authority. Just like all the other invoices for the previous 7 matters, invoices for this new matter were also addressed to Arizona Building Systems, to the attention of Wilgraven President, and used the client ID for Arizona Building Systems. If we look through the descriptions in these billable hours, we see new matter regarding Gila River development. Gila River and Indian law issues are mentioned multiple times throughout this billing. We also have Snell and Wilmer attorneys Bill Kasten, Jim Sinicki, and Mark Orr billing extensively to this new matter, which, based on the name of the matter and the description of the work performed, appears to be almost exclusively for the Gila River project. As I mentioned, Wilgraven was planning to form these 2 new companies for the Gila River project, so all of these legal services were for Wilgraven and the 2 companies he had not yet formed. None of these legal services were for ABS. So now we have Snell and Wilmer providing legal advice and services to ABS, CBS, CBS Aviation, and to Wilgraven personally on his future holding company, and now to Wilgraven personally on the 2 new companies he had not yet formed for the Gila River project, yet Snell and Wilmer continued to use the client ID for ABS. On October 12, 2005, Jim Sinicki sent this email to Wilgraven and Daniel Esposito thanking them for continuing to call on Snell and Wilmer for their legal needs. Jim Sinicki used the phrase corporate advice. Wilgraven told me he didn't need corporate advice for ABS. He needed corporate advice for his future holding company and the 2 new companies he planned to form to pursue the Gila River project, which, by the way, he will form shortly. So like many of the other legal services that Snell and Wilmer provided to Wilgraven, it does not appear that this legal advice had anything to do with Arizona Building Systems. In this email, Jim Snicki also introduced Graven and Esposito to Snell and Wilmer attorney Michael Donahue, who Jim Snicki described as his corporate law partner. So Will Graven's network of companies continues to grow with the addition of these two new companies he's planning to form to pursue the project with the Gila River Indian community. And according to this billing statement on October 12, 2005, Jim Snicki had a phone conference with Will Graven and Daniel Esposito regarding corporate advice needed. According to Will Graven, this corporate advice didn't have anything to do with Arizona Building Systems. It had to do with his future holding company and the two new companies he planned to form for the Gila River project. And then also on October 13, 2005, Michael Donahue had a phone conference with Daniel Esposito regarding the use of a holding company. And according to Will Graven, this is the only holding company that was being discussed at the time, which was Will Graven's personal holding company and had nothing to do with Arizona Building Systems. So here we have Snell and Wilmer continuing to provide legal advice to Will Graven, yet they continue to use the client ID for Arizona Building Systems. In October of 2005, Jim Snicki opened up a ninth matter titled Maricopa Metals, Inc. Will Graven recalls that ABS did need legal advice on a pending civil matter it had with Maricopa Metals. So now we're up to 9 different matters where Snell and Wilmer is providing legal advice to Will Graven, ABS, CBS, CBS Aviation, and other Will Graven companies he had not yet formed. And there are still no engagement letters. And revisiting briefly the slide I showed earlier, we're making our way through the section titled Engagement with Snell and Wilmer, which I said was going to be a very tedious portion of this presentation. Well, there are a total of 14 matters that we need to introduce, and now we're at matter 9. Once we're finished going over these 14 matters, that's when we'll see Snell and Wilmer take a position that's contrary to these facts and evidence. Specifically, they'll claim to represent only ABS and other jointly owned entities, but not Will Graven. And taking a look at another billing statement in the context of the organizational structure that is continuing to evolve. On November 2nd, 2005, Michael Donahue had a phone conference with Daniel Esposito regarding a new LLC. Arizona Building Systems didn't have any LLCs. The only new LLC at this time was Will Graven's future holding company and the two new companies he was planning to form to pursue the Gila River project. So this legal advice had nothing to do with ABS. On November 14, 2005, Daniel Esposito formed VIMDG LLC, which is an acronym for Various Investment Management and Development Group. Will Graven directed Daniel Esposito to form this company based upon the legal advice he had received from Snell and Wilmer, specifically from Jim Snicki and Michael Donahue. So if we update the organizational chart, this future holding company becomes VIMDG LLC. And if we look at another billing statement, we see that on November 29, 2005, Michael Donahue gave legal advice to Daniel Esposito regarding the formation of a holding company and next steps. VIMDG is already formed, so according to Will Graven, this legal advice was related to a new mid-level holding company that Snell and Wilmer recommended that Will Graven form. According to Snell and Wilmer's internal client files for Will Graven and his companies, this new mid-level holding company was actually 2 separate holding companies, one for the companies of which Will Graven owned 100% and one for the companies of which Will Graven owned 90.1%. And now in mid-December 2005, we see Jim Snicki opening a 10th matter titled Corporate Tax Issues. If we look at some of the terms in this billing statement, we see there are references to operating agreements and choice of entity and structural issues with respect to corporate organization. These terms are related to the network of companies that Will Graven was forming and had nothing to do with Arizona Building Systems. In mid-December 2005, Will Graven engaged Snell and Wilmer to review the fall protection program at ABS. So Jim Snicki opened this 11th matter titled ABS Safety Program. In November of 2005, Will Graven was considering a large condominium development project in downtown Phoenix. The property wasn't appropriately zoned, so Will Graven sought legal advice from Jim Snicki, who opened up a 12th matter titled Zoning at Lincoln Street Project and referred the matter to Snell and Wilmer attorney Nick Wood. According to Will Graven, it was obvious to everyone at the time that he was not going to use ABS, a steel building company, to pursue this high-rise condominium project, so Will Graven believes that Snell and Wilmer was providing this legal advice not to ABS, but to him as an individual, and just like the previous 11 matters, they continue to use the client ID for ABS. On or about November 9th, 2005, Jim Snicki opened a 13th matter titled California Corp and Licensing. And if we examine some of the descriptions in this billing statement, we see tax issues on airplanes, airplane storage, airplane property, and more on airplanes. Will Graven first started to research purchasing an airplane, not with ABS, but as an individual. And then after consulting Jim Snicki, Will Graven decided instead to form an entirely separate company to purchase the airplane. Consequently, Will Graven believes Jim Snicki was providing this legal advice to him personally and not to Arizona Building Systems. And if we examine the bottom portion of this billing statement, we see direct references to CBS Aviation Development in California, which again was a separate legal entity from ABS. So much of this legal advice was in support of CBS Aviation, yet for all these legal services, Snell and Wilmer continued to use the client ID for ABS. And now, on or about November 16, 2005, Jim Snicki opened a 14th matter titled California Labor Issues. And again, based upon the descriptions of the billable hours, these legal services were related to a handbook for California Building Systems and CBS Aviation Development, and had nothing to do with Arizona Building Systems. And now on December 6, 2005, based upon the legal advice Will Graven had received from Snell and Wilmer, Daniel Esposito formed Queen Creek Road Development, LLC, which was one of the companies Will Graven decided to form to pursue the Gila River project. And if you look at the second page of this document, you'll see that Will Graven was its only member. This was not a subsidiary of ABS. Just like all the other entities Will Graven was forming at the time, it was a separate legal entity from Arizona Building Systems. Here's an email dated December 14, 2005 from Daniel Esposito to Snell and Wilmer attorney Bill Kasten. In the email, Daniel Esposito asked Bill Kasten to do a number of things. First was to form 27 different single-member LLCs for Will Graven. These LLCs had nothing to do with Arizona Building Systems. They weren't subsidiaries of ABS. They were just 27 LLCs that were wholly owned by Will Graven. He also asked Bill Kasten to form Will Graven's mid-level personal holding company, North American Building and Development, and he asked Bill Kasten to form the second LLC for the Gila River project. All of these entities were single-member entities owned entirely by Will Graven. And on the second page of this email, Daniel Esposito provided a list of the other companies that had already been formed. Investigators discovered a copy of this email among Snell and Wilmer's internal client files for Will Graven, and we noticed that there are handwritten notes on the email that read 100% Will. So this is consistent with whomever was taking these notes, whether it was Bill Kasten or someone else from Snell and Wilmer, understanding that these companies they were forming were owned 100% by Will Graven and were separate legal entities from Arizona Building Systems. And on the second page of that same email, we again see handwritten notes that read 100% Will next to several of the companies. So there was no confusion at Snell and Wilmer about Will Graven's network of companies and who owned what. So revisiting the organizational chart, we can see that it's continuing to grow. We've got Will Graven's top-level holding company, VIMDG, the mid-level holding companies that have not yet been formed. There's this growing network of companies on the left that are owned entirely by Will Graven, and these companies on the right that are owned jointly, 90.1% by Will Graven and 9.9% by silent minority owner Deborah Debris. Snell and Wilmer will later refer to these companies on the left as Will's expansion entities, and these companies on the right as jointly owned entities or jointly owned affiliates. Here's an email dated January 4th, 2006 from Mark Orr to Mark Stryker with a copy to Daniel Esposito. The email reads, "Attached, please find our comments to the master planning contract for Queen Creek Road Development Company, LLC. Well, Queen Creek Road Development was this company down here and had nothing to do with Arizona Building Systems. This was one of the two companies Will Graven had formed for the Gila River project. If we look at the contract attached to the email, we can see it's an AIA document between Queen Creek Road Development LLC and Will Bruder Architects, which was the architect on the Gila River project. So Arizona Building Systems wasn't even a party to this agreement, yet Snell and Wilmer was providing legal advice on its contents. Now, there is a reference here to the name of the project being ABS Gila River. I asked Will Graven about that, and he said it wasn't uncommon at all for employees to refer to ABS incorrectly out of convenience because it was easier than trying to remember the names of all the different companies that Will Graven was forming. And he agreed it may have caused some inconsequential confusion among low-ranking and uninformed employees, but he does not believe it caused any confusion among the Snell and Wilmer attorneys who were advising him on corporate structure. This slide represents an overview of the different matters that Jim Snicky had opened for Wilgraven and his companies. The matters in black are matters for which ABS was the client. The matters in red are matters for which an entity other than ABS was the client. The summary is 14 separate matters, one engagement letter, and even it was unsigned. Half of these legal services were for an entity other than ABS. There were 27 different attorneys and paraprofessionals at Snell and Wilmer who provided these legal services at a cost of about $130,000 in fees, almost half of which were for entities other than ABS. The one constant across all these different matters and all these different companies is Wilgraven. I should also make clear prior to leaving this slide that while I included only the first 14 matters in this presentation, Snell and Wilmer will actually go on to open a total of 22 separate matters using the client ID for Arizona Building Systems. I don't intend to review all 22 matters because it's only the first 14 that provide the history needed to show that by December 2005 and January 2006, Snell and Wilmer had developed a fiduciary duty to Wilgraven. So that's a summary of the first 4.5 months of Wilgraven's engagement with Snell and Wilmer. And while it was lengthy and tedious to go through, the evidence as presented clearly indicates Wilgraven was Snell and Wilmer's client, and consequently, Snell and Wilmer had developed a fiduciary duty to act in his best interests and to notify him immediately of any conflicts. This is very important because soon Snell and Wilmer will engage in a scheme to falsely rewrite history and erase that fiduciary duty. But before I go into those details, I need to first describe the friendships that developed between Snell and Wilmer attorneys and Daniel Esposito because it may have contributed to Snell and Wilmer's decision to do what they did. We're going to collapse the summary of the matters onto the timeline so we can provide additional detail without cluttering the slide. On or about October 21st, 2005, Daniel Esposito sent this email to Snell and Wilmer attorneys Mark Orr, Joshua Grable, Nick Wood, and copied Mark Stryker. The email reads, "Just a reminder that Tuesday, 10:25, Mark Stryker and I would like you to be our guest for the Coyotes hockey game." Mark Orr replied, "Count me in." Here's an email dated November 3rd, 2005, from Daniel Esposito to Kayla Graven. Kayla Graven is Wilgraven's daughter and at the time managed the tickets to the ABS suites at local arenas. In the email, Daniel Esposito asked for 6 tickets to the Eagles concert for various Snell and Wilmer attorneys. He added that Snell and Wilmer was working on various matters for us, including Gila River, which is huge. So here's another confirmation that Snell and Wilmer was working on the Gila River project, which again was a project entirely separate from Arizona Building Systems. Here's an email dated November 21st, 2005, between Daniel Esposito and Mark Orr, where they plan to meet for lunch on November 22nd, meet at Daniel Esposito's house for dinner on December 10th with Daniel Esposito's wife, Jackie Esposito, and then also have a New Year's Eve hotel party on December 31st, 2005. This is a screen capture of a tool we use to conduct analysis on electronic communications, particularly email. This particular query is looking for all emails with the keyword lunch in the body of the email and sent between Esposito and anyone using the Snell and Wilmer domain SW Law. And these emails also have to exclude the word Graven as an addressee. And the total number of hits is 49 unique results between September 21st, 2005 and June 2nd, 2006. We did a similar query for the word dinner and we found 8 results between November 17th, 2005 and February 22nd, 2006. And finally, we did a similar search for the word golf and again excluding Graven and found 29 unique results between the dates shown. And we performed identical searches for lunch, dinner, and golf for the time period shown, which is prior to when Daniel Esposito joined Arizona Building Systems. In the interest of brevity, I'm only showing the results for one of these queries, but all 3 queries resulted in 0 emails. So if we put these emails onto the timeline, you can see that prior to Daniel Esposito joining ABS, we have 0 emails containing lunch, dinner, and golf between anyone at ABS and anyone at Snell and Wilmer. And then after Daniel Esposito started working for ABS, we have 29 emails containing golf, 8 dinner, and 49 lunch. And here's an email related to one such golf outing dated January 30th, 2006, in which Daniel Esposito and Thaddeus Sabarnia were planning to go golfing with Mark Orr. And the email indicates they're going to go golf tomorrow after the Big Cheese leaves at 1, which is consistent with Daniel Esposito and Ted Sabarnia not just golfing with Mark Orr, but trying to do it in a way that Wilgraven would not notice. Here's another email dated April 23rd, 2006 from Mark Orr to Daniel Esposito, which reads, "Thank you for the golf. My wife and my neighbors say thanks for the Madonna tickets, 12 tickets. Thank you." And then on April 25th, Daniel Esposito asked Mark Orr to send him the names of the recipients for the 10 tickets, and then Mark Orr replied with a list of 10 Snell and Wilmer partners and clients. And then on June 8th, 2006, Mark Orr writes, "We just left the Madonna concert. We all had a great time." And Mark Orr's wife says thank you too. So based on these emails, Daniel Esposito had obtained 10 tickets to the Madonna concert for Mark Orr at the Arizona Building Systems suite. Now, it's important to point out that Wilgraven knew at the time that some of his executives socialized with Snell and Wilmer attorneys outside of work, and sometimes Wilgraven even participated. But he had no idea that Daniel Esposito socialized so much with Snell and Wilmer, and in particular with Mark Orr at the time. On November 20th, 2006, Daniel Esposito sent this email to Mark Orr, which reads in part, "I consider you a friend and hope you think of me as the same." And in the same email, Daniel Esposito invited Mark Orr and his family to his son's 3rd birthday party. Mark Orr replied, "We would love to come," and signs the email, "Your friend, Mark." And in this email, Daniel Esposito requested and received from Jim Sinicki 4 tickets to the World Baseball Classic. Here's an email about going golf at Talking Stick on Thursday, February 23rd. And in the email, Mark Orr writes, "I only have 4 friends and 2 are already playing," referring to Daniel Esposito and Mark Stryker. So just as before, we're going to collapse all of this detail down onto the timeline so it doesn't clutter the slide as we continue with the presentation. On December 9th, 2005, Daniel Esposito wrote a letter of appreciation to Jim Sinicki in which he praised the work done by Mark Orr, Joshua Grable, and Josette Malika. And a few days later, on December 12th, Daniel Esposito forwarded a copy of the letter he had written to Mark Orr, Joshua Grable, and Josette Malika to make sure they were each aware of the letter. The timing for this email is just 2 days before Daniel Esposito will ask Snell and Wilmer to rewrite the ABS shareholder agreement, which I will explain in great detail in a moment. So that gives you an idea of how friendships formed between Daniel Esposito and various Snell and Wilmer attorneys, in particular with Mark Orr. So now we're going to move forward and talk about the conspiracy to take over ABS. And as we go through this section of the presentation, we'll see several additional emails indicative of a continued friendship between Daniel Esposito and Mark Orr. In late 2005, there were several separate meetings between Wilgraven, Deborah Debris, and different members of the ABS executive team. The purpose of this graphic is to convey the nature and timing for the conversations that took place during these various meetings. To start, according to both Wilgraven and Deborah Debris, he on several occasions told her about all the exciting projects he was pursuing and how ABS was going to make a lot of money and was on a very positive trajectory. Deborah Debris started to share Wilgraven's enthusiasm and positive outlook with the ABS executive team and told them that ABS was going to make hundreds of millions of dollars. She also started to experience feelings of regret and resentment toward Wilgraven because at the time she believed he had taken advantage of her since he acquired ABS for essentially nothing. According to Deborah Debris, the executive team responded by telling her Wilgraven was lying. He was incompetent, knew nothing about construction, and was driving ABS into bankruptcy. They also told Deborah Debris they could do a much better job running the company than Will was doing. So they agreed to work together to force Wilgraven out of the company and take control of ABS. Deborah Debris was going to more than double her equity stake in ABS to 20% and remain a silent partner, and the ABS executive team was going to take 80% ownership and oversee day-to-day operations. Deborah Debris and Daniel Esposito also agreed to direct Snell and Wilmer to rewrite the ABS shareholders agreement to give Daniel Esposito and Deborah Debris a means to force Wilgraven out of the company so that they can take control of ABS. In the wake of these meetings between Deborah Debris and the ABS executive team, Daniel Esposito sent this email to Bill Kasten. He attached a draft shareholders agreement and asked Snell and Wilmer to add several clauses. One of the clauses was related to Deborah Debris' employment agreement. He indicated it was guaranteed by ABS and by Will Graven personally, and claimed it was valid through October 5, 2010. None of this is true. As I explained earlier, her employment agreement was voided when she accepted 9.9% ownership in ABS. Daniel Esposito also requested a clause he described as right of first refusal. Will Graven told me he would have never approved such a clause. He said if he decided to sell his shares to a third party at the time, he didn't need the transaction hampered by having to give Deborah Debris an opportunity to purchase his shares first. Daniel Esposito also requested a clause he described as restrictions on purchases, salaries for family members or related parties. Will Graven told me he wouldn't have agreed to any restrictions and now believes the executive team wanted this added to restrict purchases he believed were needed just to operate the company day to day and to limit what he could pay his 3 children who also worked for ABS at the time. Daniel Esposito also requested a clause he described as protection against either member or stockholder becoming married. Will Graven told me he would have never agreed to this and now believes the executive team wanted this added because at the time he was engaged to another ABS employee by the name of Terry Pfeiffer. Daniel Esposito requested another clause he described as recourse against any member regarding for-cause situations. Based upon documentary evidence I'll present shortly, this is the clause that would later enable the executive team to force Will Graven out of ABS by making felonious allegations against him and attacking his business acumen. Now, many of these clauses might be reasonable in a shareholders agreement where ownership is more evenly distributed amongst several shareholders, but Will Graven was a 90.1% owner and Deborah Debris was a 9.9% silent owner. Will Graven had no interest in giving Deborah Debris any control over any aspect of the company, and he certainly never agreed to pay Snell and Wilmer to make these proposed changes. And if we look at the header of this email, we see that Daniel Esposito did not copy Will Graven. So Will Graven had no idea that Daniel Esposito had directed Bill Kasten at Snell and Wilmer to make any changes to the shareholders agreement. Now let's take a closer look at the draft shareholders agreement that Daniel Esposito attached to his email to Bill Kasten. So on the first page of this agreement, we see that it's dated October 5th, 2005, which is the date Will Graven exercised his option. Here is some verbiage that restricts what happens to Will Graven's shares in the event of his death, rather than those shares going to his heirs as he wanted. This language gives Deborah Debris the right to acquire those shares. And the bottom of this page and the top of the next page just further restricts what Will Graven could do with his shares. Anything he wanted to do with his shares would be subject to this agreement. Here's the right of first refusal language. So if Will Graven decided to sell his shares, he would need to give written notice to Deborah Debris, and Deborah Debris shall have the option to purchase those shares according to the same terms. Again, this is not something Will Graven would have ever agreed to because it would have severely hampered what he could do with his own shares. And this is probably the clause that is most applicable to the allegations against Snell and Wilmer and the ABS executive team. This language allows the corporation to terminate one of the stockholders for cause as determined by the board of directors. And rather than Will Graven being the only board member as he wanted, this new shareholders agreement required that the board consist of 3 people. And we'll learn later that those 3 people are Will Graven, Daniel Esposito, and Deborah Debris. This draft shareholders agreement also indicates that the stockholders will vote his respective shares of stock for each of the following as a director of the corporation. Will Graven had no interest in Deborah Debris serving as a director of the corporation. She was to be a 9.9% silent minority owner. And the language at the bottom of the page, which reads, each stockholder will cause each of the following persons to be appointed and elected to an officer of the corporation. Will Graven would have never approved having Deborah Debris or Daniel Esposito serve as officers of the company. So the net is Will Graven didn't agree with any of these changes, and at this point would have expected someone from Snell and Wilmer, Bill Kasten in particular, to notify him immediately that Daniel Esposito was attempting to make such changes. On December 14, 2005, Bill Kasten responded to Daniel Esposito's email, copied Mark Orr, and wrote, I received your email and will review it to let you know my initial thoughts. Just a few minutes after the email from Bill Kasten, Deborah Debris sent this email to Ted Sabarni and Mike Martin with an attachment titled Signing Authority and Review Processes.doc. The email reads, My middle of the night thoughts, things to consider when we reach a point where we start drilling down. If we look at the attachment, it reads Signing Authority ABS or CBS and Review Approval Process ABS or CBS. This is an outline for Deborah Debree's proposed processes for day-to-day operations at ABS and CBS. At this point, Deborah Debree was supposed to be transitioning out of the company and minimizing her contact with ABS employees. In fact, she's supposed to be completely removed from the company by December 31st, 2005, which is just 2 weeks later. Instead, she sent this email to Ted Sabarnia and Mike Martin proposing operational processes for ABS and CBS. And if we examine what she wrote in the body of her email, things to consider when we reach a point where we start drilling down, it's clear there's a plan in place. And Will Graven isn't copied anywhere on this email exchange. And on the same day, here's an email from Daniel Esposito to Deborah Debree that reads, Per your request, I've made the necessary modifications to the agreements, and I've sent them for evaluation to Snell and Wilmer. Their comment should be back to us next week. And on the same day, Snell and Wilmer attorney Michael Donahue billed 0.2 hours for work he described as phone conference with Deborah Debree regarding corporate reorganization, follow-up regarding same. At this point, Will Graven believed that Deborah Debree was transitioning out of the company and didn't expect her to be soliciting legal advice from Snell and Wilmer. And he didn't notice this on the billing at the time. He trusted Daniel Esposito to review these bills and make sure they were authorized charges. And even to this day, Will Graven doesn't understand what corporate reorganization refers to. He was, in fact, establishing a large network of companies, but he was doing it through his consultations with Jim Sinicki, Mike Donahue, and Daniel Esposito, and Deborah Debree wasn't involved in any way. He also doesn't understand why Snell and Wilmer continued to give legal advice to Deborah Debree and then charge him at ABS for the advice. Now, during subsequent interviews with Deborah Debree, she acknowledged that she and Jim Sinicki had a long history that predated Will Graven. They had known each other for several years as they were both longtime members of the CFMA, which met monthly and sponsored several social events and golf outings. Will Graven now believes this prior history between Jim Sinicki and Deborah Debree, in addition to the close friendship that had formed between Daniel Esposito and Mark Orr, may have caused Snell and Wilmer to favor Deborah Debree rather than always represent him and his best interests. And we'll see going forward that the evidence supports Will Graven's position. And still on the same day, December 14th, 2005, the day that Daniel Esposito first asked Bill Caston to make changes to the shareholders agreement, which were against Will Graven's interests, Bill Caston sent this email to Daniel Esposito, copied Mark Orr, and wrote, in part, Dan, I think you and I should meet prior to my meeting with Will to make sure that we are on the same page. Then on the same date, Bill Caston billed 1.8 hours he described as discussion with Dan Esposito regarding operating agreements, follow-up call with Esposito regarding choice of entity and structural issues with respect to corporate organization. On December 20th, 2005, Daniel Esposito sent this email to Deborah Debree, which reads, Hi Deborah, Mike Donahue, the tax attorney at Snell and Wilmer, will meet us at our office tomorrow at 9:30 a.m. to discuss the issues with the entities. This is less than 2 weeks before Deborah Debree was supposed to be transitioned out of the company entirely. And now she and Daniel Esposito are meeting with Snell and Wilmer to discuss issues with the entities. Michael Donahue wasn't a tax attorney, by the way, as we saw in an earlier email from Jim Sinicki. Michael Donahue was a corporate law partner at Snell and Wilmer. The email indicates the meeting would be on December 21st at 9:30 a.m. The investigation confirmed that on that date, Will Graven was in Victorville, California, and knew nothing about Michael Donahue's meeting with Daniel Esposito and Deborah Debree. On December 27, 2005, according to this billing statement, attorney Bill Caston had a meeting with Daniel Esposito. Will Graven recalls that immediately after that meeting, he met with both Bill Caston and Daniel Esposito to discuss his vision for his network of companies and for the Gila River project. During this face-to-face meeting, Bill Caston failed to even mention the significant changes that Daniel Esposito had asked him to make to the ABS shareholders agreement. Immediately after Will Graven's meeting with Bill Caston, Daniel Esposito sent this email to Bill Caston, which reads, Don't want to say I told you so, but... Now, it's difficult to know for sure what Daniel Esposito meant by this email. But Will Graven believes it's consistent with Daniel Esposito telling Bill Kasten prior to the meeting with Will Graven that Will Graven's vision for the Gila River project and his network of companies were wildly unrealistic. And then after Will Graven's meeting with Bill Kasten, Daniel Esposito sends this email writing, "I told you so." Later the same day, on December 27th, Bill Kasten sent this email to Daniel Esposito, which reads, "Which are Deb's concerns, or are all of them Deb's concerns?" Bill Kasten was referring to the changes that Daniel Esposito had asked him to make to the ABS shareholders agreement. Daniel Esposito replied, "Yes, the email I forwarded to you below are all of Deborah's concerns." So at this point, Daniel Esposito confirmed what Bill Kasten had apparently concluded, that the requested changes were for Deborah Debris and not Will Graven. Yet Bill Kasten still failed to call Will Graven immediately and notify him of what Daniel Esposito and Deborah Debris were attempting to do. So to review where we're at, prior to early January 2006, there were 14 separate matters and no signed engagement letters. Half of the matters were for legal services to entities other than ABS. There were 27 different attorneys and paraprofessionals at Snell and Wilmer, led by Jim Sinicki, who provided more than $130,000 in legal services, $60,000 of which were for entities other than ABS. The one constant among all the entities was Will Graven. And based upon this well-documented 4.5-month history, Will Graven trusted Snell and Wilmer and believed they had a fiduciary duty to act in his best interest and to notify him immediately of any conflicts. Rather than honor this fiduciary duty and notify Will Graven immediately of what Daniel Esposito and Deborah Debris were doing, on January 3, 2006, Bill Kasten billed 2.4 hours he described as Arizona Building Systems org chart and related issues regarding representation. And then on January 4th, 2006, he billed an additional 2.4 hours he described as disclosure letter, org chart, discussions with Mark Orr and Jim Sinicki regarding representation. On January 4th, 2006, Jim Sinicki also billed 0.6 hours he described as evaluate corporate chart and future tactics, phone conference with D. Esposito regarding same, follow-up and coordination regarding same. So on January 3rd, 2006, Bill Kasten billed work related to an org chart and representation, and then the next day on January 4th, Jim Sinicki consulted Daniel Esposito, and Bill Kasten, Mark Orr, and Jim Sinicki all met to discuss an org chart and representation. This is a copy of handwritten notes that we found among Snell and Wilmer's internal client files for Will Graven and his companies. One thing that's noteworthy about these notes is where Arizona Building Systems fits within the overall organizational structure of Will Graven's entities. The individual Will Graven is at the top, his holding companies are beneath him, and then beneath the holding companies on the right are the LLCs of which Will Graven owns 100%, which are the same LLCs that Daniel Esposito had directed Bill Kasten to form, and then on the left are some of the jointly owned entities. So whoever wrote these notes seems to have a pretty clear understanding of the network of companies and the fact that Arizona Building Systems was a separate legal entity from the rest. So the idea that Snell and Wilmer could believe, as Jim Sinicki will state shortly in a new representation letter, that the legal services they provided for the previous 4.5 months were for ABS and the other jointly owned entities and not for Will Graven, contradicts the facts as shown in the documents presented up to this point, as well as these handwritten notes, which again were prepared by someone at Snell and Wilmer, very likely during the January 4th meeting I described in the previous slide. Something else that's remarkable about these handwritten notes is, can we represent Will alone? See top right box. And in the top right box it reads, authorized to go through Dan Esposito and acknowledgement from Debris that we represent Graven on other matters. The step authorized to go through Dan Esposito is exactly what we're going to see play out going forward. We also found among Snell and Wilmer's internal client files this organizational chart, also with handwritten notes that detail a 6-step plan. The first step reads, separate client numbers and engagement letters for each jointly owned affiliate. And then there's a line down to the row in the org chart that corresponds to the jointly owned affiliates, which are the companies that were owned jointly by Will Graven through one of his holding companies and by Deborah Debris. Step 2, according to these handwritten notes, is a DNR by Deborah Debris, which is consistent with does not represent Deborah Debris. So if this 6-step plan is executed, I would expect to see an engagement letter that indicates Snell and Wilmer does not represent Deborah Debris. And then for step 3, there is another DNR notation next to Will Graven regarding his interest in jointly owned entities. So again, if this 6-step plan is going to be carried out, I would expect to see an engagement letter addressed to Will Graven that makes it clear in writing that Snell and Wilmer does not represent Will Graven's interest in the jointly owned entities. Step 4 reads separate client numbers and engagement letters for estate planning and prenup only. So Snell and Wilmer was doing some estate and premarital planning for Will Graven, and it appears according to the 6-step plan that they intended to continue providing Will Graven with these sorts of legal services, but they would require separate client numbers and engagement letters. Step 5 is over by NABD, which is the entity through which Will Graven owned all of his expansion entities. It reads separate client number and engagement letter, and subs have separate matter numbers. Step 6 reads conflict waiver regarding employee leasing. Snell and Wilmer had already been working on leasing agreements between ABS and other Will Graven companies because many ABS employees worked for these other companies. So it appears based on this 6-step plan that Snell and Wilmer intended to continue providing these legal services as well. So after 4.5 months of not needing any signed engagement letters, now in the wake of Daniel Esposito asking Snell and Wilmer to make changes to the shareholders agreement that were against Will Graven's interests, Snell and Wilmer decides to write new engagement letters that make it clear in writing that Snell and Wilmer does not represent Will Graven as an individual in jointly owned entities, one of which is ABS. So Snell and Wilmer cannot make the changes to the shareholders agreement with the way things were because even they recognized they had a fiduciary duty to Will Graven. So in order to make the changes to the agreement, they needed to first change the engagement they had with Will Graven to erase their fiduciary duty. And as we move forward with this presentation, we'll see how Snell and Wilmer executes this 6-step plan. So the first thing they needed to do before executing their 6-step plan is to authorize to go through Daniel Esposito. On January 4th, 2006, which is the same day Jim Sinicki had the phone conference with Daniel Esposito and met with Mark Orr and Bill Caston to discuss representation, Jim Sinicki sent this letter to Daniel Esposito. The letter reads, as you know, Snell and Wilmer represents Arizona Building Systems as well as its affiliates which are owned in the same manner and in the same proportion as ABS, collectively the jointly owned affiliates listed below. In this regard, you have advised the company's shareholders, i.e. Will Graven and Deborah Debris, that Snell and Wilmer does not represent either of them individually and that they should retain their own counsel as they desire. We understand that all necessary approvals have been obtained, member approval, shareholder approval, board resolutions, etc., from ABS and each jointly owned affiliate, authorizing you in your capacity as general counsel to prepare with our assistance the respective organizational documents and authorizing the use of the respective resources, employees, management, overhead, etc., for those entities owned directly or indirectly by Will Graven, whether currently formed or not, collectively Will's expansion entities, subject to any agreements entered into by and among ABS and Will's expansion entities, which we will assist you in preparing. So rather than Jim Sinicki or anyone from Snell and Wilmer contacting Will Graven directly and saying, hey, we just wanted to verify that you authorized Daniel Esposito to do these things, rather than contacting Will Graven directly and saying, hey, Daniel Esposito just asked us to make a lot of changes to the shareholders agreement that are clearly against your interests and in the interest of Deborah Debris, rather than contacting Will Graven directly, Jim Sinicki instead writes Daniel Esposito this letter. He doesn't copy Will Graven, and he writes, we trust that you have obtained all the necessary approvals. We're not going to do anything to check or verify what you claim, but instead, by virtue of this letter that we wrote and will ask you to sign, we accept that you have obtained all the necessary approvals and that you also notified Will Graven that Snell and Wilmer doesn't represent him individually on matters related to the jointly owned entities. Jim Sinicki is relying entirely on one of the people who stand to benefit from the changes to the corporate documents rather than notifying Will Graven directly. This letter falsely rewrites history and erases Snell and Wilmer's fiduciary duty to Will Graven. The second page is signed by Jim Sinicki, and among Snell and Wilmer's internal client files for Will Graven and his companies, investigators found the version countersigned by Daniel Esposito. This letter is authorizing to go through Daniel Esposito. And now that they've given themselves the authority to go through Daniel Esposito, they'll be able to execute their 6-step plan without Will Graven ever being informed. And Jim Sinicki's letter referenced the jointly owned entities, so here's a quick reminder of what those entities are and where they fit into the organizational chart. And you can see that it's very similar to the handwritten notes that we found in Snell and Wilmer's internal client files for Will Graven and his company. So there was no confusion at Snell and Wilmer regarding who owned what. And this is important because soon Bill Caston will claim that Will Graven's network of companies was not previously clear. And Jim Sinicki will later take a new interest in avoiding confusion. The same confusion he enabled by not requiring any engagement letters and not having any of these critically important discussions directly with Will Graven. On January 12, 2006, Deborah Debris sent this email to Daniel Esposito and asked, in part, "What's the latest at Snell and Wilmer?" Daniel Esposito replied, "Snell and Wilmer are working on the agreements." On January 12, 2006, Bill Caston sent this email to Daniel Esposito, which reads, "Please call me at your convenience." Daniel Esposito apparently called him because Bill Caston follows up with an email that reads, "Good speaking with you this afternoon." This email has the subject line, "Various representations," and consistent with Snell and Wilmer's plan to go through Daniel Esposito, Bill Caston does not include Will Graven on this email. He does include Mark Orr and Jim Sinicki. So as a reminder, it was these three attorneys, Bill Caston, Mark Orr, and Jim Sinicki, who met on January 4th to discuss an org chart and representation, during which they decided unilaterally to go through Daniel Esposito to execute their 6-step plan. Now, in this email, Bill Caston first reiterates what Jim Sinicki wrote in his January 4th letter, the letter that falsely rewrote history and erased his fiduciary duty. Bill Caston writes, "I understand that you have openly discussed all these matters with Will Graven and Deborah Debris." So just as Jim Sinicki did, Bill Caston is now also relying entirely upon Daniel Esposito to keep Will Graven informed, even on matters that were against Will Graven's interests and to the benefit of Daniel Esposito. And just as Jim Sinicki did, Bill Caston blindly trusted Daniel Esposito and did nothing to independently confirm that Daniel Esposito did in fact openly discuss these matters with Will Graven. This email and Jim Sinicki's January 4th letter are probably among the most important data points in this entire presentation. No reasonable person would believe that Will Graven, as a 90.1% owner of ABS, would give Deborah Debris and Daniel Esposito control over the company. Jim Sinicki, Bill Caston, and Mark Orr had to have known this, which is why they never mentioned it directly to Will Graven. And instead, they put into writing that they believed Daniel Esposito had openly discussed all these matters with Will Graven, not because they believed it was true, but because they wanted to eliminate their future culpability. And in the rest of the email, we'll see Bill Caston explaining the 6-step plan to Daniel Esposito. Here is step 1, jointly owned entities. He writes, "It is now clear that there are multiple entities separate and distinct from ABS, each of which is seeking separate representation by Snell and Wilmer. It had been clear for several months that there were several entities separate and distinct from Arizona Building Systems. Bill Caston knows this because he helped form the entities. So for Bill Caston to write in this email that it is now clear is again falsely rewriting history. He's implying it wasn't clear before when it had been clear for months." Bill Caston also writes, "And to ensure that there is no confusion, it is necessary that we prepare separate engagement letters for each of the entities. Similarly, each entity will have a separate client number for billing purposes." So for almost 5 months, it was okay to proceed with the confusion of not properly managing their engagement with Will Graven. But now, in the wake of Esposito asking Snell and Wilmer to make changes to the corporate documents that were against Will Graven's interests, they want to minimize confusion and make it very clear in writing that Snell and Wilmer does not represent Will Graven with regard to the jointly owned entities. This will then allow them to make the changes to the shareholders agreement. They can't make them now because even they realize they currently have a fiduciary duty to Will Graven. They need to first erase that fiduciary duty. Here is step 5, Graven-owned entities, separate client number and engagement letter, and according to this email, that's exactly what they plan to accomplish. Step 6 is about how they plan to prepare conflict waivers for the leasing agreements, if Snell and Wilmer represented ABS or the Graven-owned entities during negotiations. Step 2 and 3, no representation of individual owners with respect to the jointly owned entities. This is the step that they believe will allow them to make the changes to the shareholders agreement. And on the second page of the email is step 4, separate client and engagement letters for estate planning and prenuptial only. So Snell and Wilmer intends to continue the representation of Will Graven on personal non-corporate matters. So Bill Kasten has explained to Daniel Esposito all 6 steps of their 6-step plan. On January 19, 2006, Bill Kasten sent this email to Daniel Esposito and copied Jim Sinicki. The email reads, I spoke with Jim Sinicki. He will review the engagement letters tomorrow, and pending his comments as well as his discussions with Deb, will send them out likely Monday or Tuesday of next week. So this email reads, as well as his discussions with Deb. So it appears Jim Sinicki planned to discuss the new engagement letters directly with Deborah Debris, but consistent with their plan to go through Daniel Esposito, he did not copy Will Graven. And in the midst of all this, we still have the personal friendship evolving between Mark Orr and Daniel Esposito. In this email, Daniel Esposito requested tickets to the FBR Open, which at the time was the Phoenix Open. In the email, Daniel Esposito repeated what an invaluable role Mark Orr served in the Gila River project. Here's an email from Jim Sinicki to Daniel Esposito, which reads, as you know, we are opening up many new client numbers for various related entities and the new WG entity. My accounting office has informed me that $30,000 roughly billed on 12/14 is past due. Can you get this paid this coming week promptly? Jim Sinicki didn't include Will Graven on this email. Now, I wouldn't necessarily expect him to copy Will Graven on every email sent to Daniel Esposito, but I found 19 other emails from Jim Sinicki that were also related to billing that he did send to Will Graven, so it's not clear why he excluded Will Graven from this email and not the others. However, this email does reference opening many new client numbers, which was among the matters to which Bill Kasten referred when he wrote in his email to Daniel Esposito, I understand that you have openly discussed all these matters with Will Graven and Deb Debris. So this is one possible explanation for why Jim Sinicki did not include Will Graven on this email, so he would not directly reveal to Will Graven their intention to open up new client numbers. Investigators obtained certified bank records for ABS, and these records show that Will Graven was in the office on January 23rd signing checks. He signed 12 checks, including each of these on January 23rd. But Daniel Esposito asked Deborah Debris to sign this check to Snell and Wilmer. Will Graven told me Snell and Wilmer knew at the time that Deborah Debris was a 9.9% silent minority owner who had exited the company on December 31st, 2005. Yet they didn't question why they were receiving a check signed by Deborah Debris and not Will Graven. In light of all the other things that were happening at the time between Snell and Wilmer, Daniel Esposito, Deborah Debris, and Will Graven vis-a-vis the changes to the shareholders agreement, this by itself should have caused Snell and Wilmer to ask questions, but they didn't. One possible reason is because they already knew the answers. They knew what Daniel Esposito and Deborah Debris were doing, but in order to move forward in a way that ameliorated their culpability, they needed to not ask questions, but continue to blindly trust Daniel Esposito and go through him for everything. On January 24, 2006, Bill Kasten sent this email to Daniel Esposito and copied Jim Sinicki, Mark Orr, and Mark Bond, who was another Snell and Wilmer attorney who at the time worked on Will Graven's estate planning and prenuptial agreement. The email reads, Jim has completed and signed the various letters, i.e. engagement and other letters to Will and Deborah clarifying who we represent. Once Deb, Will, and you sign each of the letters, I can get started on the documents. So this email makes it very clear that Bill Kasten isn't going to make any changes to the corporate documents until Deborah Debris, Will Graven, and Daniel Esposito signed the new representation letters. So this is further evidence that Bill Kasten, Mark Orr, and Jim Sinicki recognized the changes to the shareholders agreements were against Will Graven's interest, and because of their existing fiduciary duty to Will Graven, they couldn't make those changes until Will Graven signed the new representation letters, which made it very clear in writing, if not in practice, that Snell and Wilmer did not represent Will Graven on the jointly owned entities. This would allow Snell and Wilmer to do things related to the jointly owned entities that were against Will Graven's interests. And again, They didn't copy Will Graven on this email because they were continuing their plan to go through Daniel Esposito. Not once did they communicate any of this information directly to Will Graven. And it's also worth pointing out that when Bill Caston described the letters as clarifying who we represent, he was falsely implying that there was some confusion related to representation, and there wasn't any. Snell and Wilmer represented Will Graven. If Bill Caston was being honest, he would have described the letters as changing who we represent. On January 26, 2006, the relationship between Daniel Esposito and Mark Orr continued to deepen. In this email, Daniel Esposito writes, "I trust your judgment in all the matters you are handling. You are my friend foremost as well as my colleague." On January 27, 2006, Bill Caston sent this email to Daniel Esposito, which reads, "How are the engagement and other letters doing? If signed, do you want to have a brief call next week before I dive in?" Again, Bill Caston continues to wait before making any changes to the shareholders agreement until he gets confirmation that the new engagement letters were signed by Will Graven. Daniel Esposito replied, "Done. Dropped them off yesterday with Mark Orr." Snell and Wilmer now has the signed documents they need to make the changes to the ABS corporate documents. If we take a close look at the representation letter that Jim Sinicki drafted and gave to Daniel Esposito to get Will Graven to sign, it reads very clearly, "With respect to our representation of each jointly owned entity, including but not limited to drafting the operating agreements and similar organizational documents for each jointly owned entity, our only client will be, in each instance, the jointly owned entity and not you or Ms. Deborah Debris. Although we will represent you in limited matters unrelated to the jointly owned entities as specifically set forth in a separate engagement letter between you and Snell and Wilmer, we will not represent you in any matter with respect to the jointly owned entities, including but not limited to negotiating and drafting the operating agreements and similar organizational documents for each jointly owned entity." The fact that Jim Sinicki would include the verbiage drafting the operating agreements and similar organizational documents twice is consistent with Jim Sinicki again proactively trying to eliminate Snell and Wilmer's culpability for the acts they were about to commit. That is, make changes to the shareholders agreement that were against Will Graven's interests. And the letter continues, "As you know, Snell and Wilmer represents WG North American Building and Development LLC in matters unrelated to the jointly owned entities." And the second page of the letter, for the third time, specifically identifies what they're about to do. "With respect to drafting the operating agreements and organizational documents, we will, of course, provide you, either directly or if you should decide to retain counsel, through that counsel." And we'll see later that's exactly what they're going to do, provide copies of the new shareholders agreement to Will Graven through Daniel Esposito. And now for the fourth time, Jim Sinicki specifically mentions the operating agreement. "With respect to our representation of the jointly owned entities, including but not limited to our preparation of the operating agreements, we will only be representing the jointly owned entity and protecting only its interests." We will later see that even this is false, as Snell and Wilmer will later try to protect Deborah Debris' interests in ABS, which is a jointly owned entity. And the letter continues, "I know you have a good relationship with each jointly owned entity and Deborah Debris. However, in a business relationship such as this, matters may arise where the interest of a jointly owned entity or Deborah Debris differ from yours. In such circumstances, we will be representing only the jointly owned entities, as the case may be, and not your interests. You have acknowledged that you understand that to be the case." Jim Sinicki writes that matters may arise, like it's some future possibility. As he wrote this letter, he knew with certainty that Snell and Wilmer had already been asked to do something that was against Will Graven's interests. But in this letter, he falsely described it as some possible event that might happen someday in the future. He also writes, "I have not sent this letter because I foresee difficulties between you and any of the jointly owned entities or Deborah Debris in the future." This statement blatantly contradicts the facts. Jim Sinicki knew Snell and Wilmer was about to make significant changes to the corporate documents that were against Will Graven's interests. The only way this would not have created difficulties is if they planned to conceal the changes from Will Graven into perpetuity. The letter continues, "It is prudent, however, to make sure up front that there is no misunderstanding about the relationships between our firm and those with whom we have dealings. That's why I'm writing this letter now." It was prudent to eliminate misunderstandings 5 months ago. It wasn't until Daniel Esposito asked Bill Caston to change the shareholders' agreement, contrary to Will Graven's interest, before Jim Sinicki decided it was prudent to put the scope of their representation into writing. So after 5 months of representing Will Graven as an individual on a variety of corporate matters, including the jointly owned entities, his expansion entities, and as an individual on private matters, and leading Will Graven to believe that he was Snell and Wilmer's client, this new representation letter carved out a jointly owned entities exception. So Jim Sinicki's saying, Will, we're going to represent you and your companies. We're going to help you with your estate planning, your prenuptial agreement. We're going to help you with the complexities of the Gila River project. We're going to help you with all of these matters. We are your go-to attorney for all your legal needs. However, if it has anything to do with these jointly owned entities, then we're going to do things that are against your interests, and it's okay. And rather than tell Will Graven about this precisely crafted jointly owned entities exception, they continued with their plan to go through Daniel Esposito. And if we compare the first page of Will Graven's letter with the first page of Deborah Dupree's letter, it confirms what we already know. Will Graven's reads, I would like to confirm the relationship between, and Deborah Dupree's reads, I would like to confirm what I told you about the relationship between. And Deborah Dupree's letter reads, as I mentioned to you, where Will Graven's letter is missing those words entirely. Since Snell and Wilmer communicated with Will Graven indirectly through Daniel Esposito, Jim Sinicki cannot use that same language. All 6 steps in their 6-step plan are now complete, so they are free to make the changes to the shareholders agreement. Here's the signature page for the engagement letter with the jointly owned entities exception. Will Graven told me that on or about January 23, 2006, Daniel Esposito approached him and said that since Snell and Wilmer was going to be working on his will, estate planning, and prenuptial agreement, that Snell and Wilmer attorney Mark Bond needed him to sign 2 or 3 engagement letters. Daniel Esposito presented the signature page for each of the letters, and Will Graven signed each. Will Graven said he trusted Daniel Esposito as his friend, as his personal attorney, and as his inside corporate counsel. So when Daniel Esposito asked him to sign new engagement letters, Will Graven just signed the documents. This is precisely the sort of behavior that Snell and Wilmer could have prevented if they simply communicated directly with Will Graven. And here's an email dated January 24, 2006, in which Daniel Esposito, Mark Orr, and Mark Bond discussed Will's trust and estate planning. The date on the representation letter with the jointly owned entities exception is January 23, 2006, 1 day earlier. So the timing was perfect for Daniel Esposito to use the will and estate planning matters as a ruse to trick Will Graven into signing the new representation letters, which included the jointly owned entities exception. And the allegation that Daniel Esposito used the will and estate planning matters as a ruse to trick Will Graven into signing different representation letters is further supported by what we found in the actual representation letter for the will and estate planning matter. It does not have Will Graven's signature. Will Graven now believes that Daniel Esposito didn't ask him to sign the actual will and estate planning engagement letter because he had already used that excuse to trick him into signing the other letters. On January 28, 2006, the relationship between Daniel Esposito and Mark Orr continued to evolve as they planned to go to a Super Bowl party. On January 31, 2006, Bill Caston sent this email to Daniel Esposito, which reads, "Please call me to discuss the attached org chart." If we look at the org chart attached to Bill Caston's email, we can see that it represents a very clear and accurate understanding of Will Graven's network of companies. I should also point out that the arrows that come out radially from ABS represent the leasing agreements I described earlier, which enabled ABS employees and overhead to be allocated as needed to other organizations. So with the new engagement letters, Snell and Wilmer would have Will Graven believe that they represent Will Graven on personal matters, on personal and corporate matters related to VIMDG, on personal and corporate matters related to NABD, on personal and corporate matters related to these holding companies, on personal and corporate matters related to all these entities. But when it comes to these jointly owned entities, they were free to do whatever they wanted, even if it was against Will Graven's interest. And they didn't even have to notify Will Graven of the conflict. On February 6, 2006, Daniel Esposito sent this letter to the Arizona Corporation Commission, which reads in part, "We would like to remove Deborah Debris as President CEO and appoint Will Graven as acting President CEO, effective October 5, 2005. Which is the date that Will Graven exercised his option. Esposito's use of the word acting is consistent with him believing for some reason that Will Graven's role in the company would be temporary, which is again consistent with Daniel Esposito, Deborah Debris, and the executive team's ongoing effort to force Will Graven out of the company. In this letter, Daniel Esposito also appointed himself as acting corporate secretary, which is not something Will Graven ever approved. On February 8, 2006, Daniel Esposito sent this email to Bill Kasten and asked for a copy of the ABS shareholders agreement. And later that same day, Bill Kasten sent this email to another Snell and Wilmer attorney, Garth Stevens, which reads, "Garth, see the client's email below and their attached draft. If you would rather use a form you're more comfortable with, then feel free to scrap his. Let's talk when you can. Also, please let me know what your timing looks like. As always, the client wanted it yesterday." So according to this email, Daniel Esposito had expressed some sort of urgency when he asked Bill Kasten for a copy of the new ABS shareholders agreement. And now Bill Kasten is forwarding the task to change the shareholders agreement to Garth Stevens. On the same day, February 8, 2006, another ABS employee, Mike Torreson, sent this email to several people, including Mark Orr, and copied Will Graven. The email reads, "Will requested that you attend a meeting tomorrow, Thursday at 10 a.m. in the conference room to discuss proposed changes and or modifications to the proposed lease agreements for Gila River." Daniel Esposito received confirmation that Mark Orr would attend the meeting because about 25 minutes later, he notified Will Graven that Mark Orr would be attending the meeting. On February 9, 2006 at 10 a.m., Will Graven attended the meeting between Mark Orr, Daniel Esposito, and several others to discuss the Gila River project. Before, during, or after this face-to-face meeting with Will Graven, Mark Orr could have talked to Will Graven directly about the entirely new engagement letters and the jointly held entities exception, or the planned changes to the shareholders agreements. But consistent with Snell and Wilmer's plan to go through Daniel Esposito, Mark Orr said nothing. On February 13, 2006, Garth Stevens forwarded the email he had received from Bill Kasten to another Snell and Wilmer attorney, Brian Burt. So Bill Kasten forwarded Daniel Esposito's request to modify the shareholders agreement to Garth Stevens, and then Garth Stevens forwarded the request to Brian Burt. All three are Snell and Wilmer attorneys. On February 13, 2006, Brian Burt billed 0.6 hours for work he described as discussion with B. Kasten regarding preparation of shareholders agreement for Arizona Building Systems and prepare same. So now Snell and Wilmer attorney Brian Burt is starting to work on the changes that Daniel Esposito and Deborah Debris had first requested from Bill Kasten back on December 14th of 2005. And on February 15th, 2006, Brian Burt billed another 4.8 hours for work he described as review D. Esposito's draft of shareholders agreement for Arizona Building Systems and related email and prepare same. And on February 15th, 2006, as Brian Burt is working on the ABS shareholders agreement, Mark Orr sent this email to Daniel Esposito, which reads in part, "Attached are all the articles of organization that need your signature. Also attached is an org chart for your file. As always, thanks for the work." If we look at the attachment titled Organizational Chart and Articles of Organization.pdf, we see it contains 31 different articles of organization for all the companies owned solely by Will Graven through his holding companies. And if we look at the other attachment titled Will Graven Org Chart.ppt, we see it is similar to the org chart we saw earlier. And if we look in the lower right-hand corner and look at the Exhibit A, we see that it identifies several more companies, all wholly owned by Will Graven through his holding companies. So according to this email, Snell and Wilmer completed the articles of incorporation for these companies and then sent them to Daniel Esposito for his signature as statutory agent. And this is consistent with Snell and Wilmer continuing to represent Will Graven on corporate matters related to his expansion entities. At the time, Will Graven continued to believe that Snell and Wilmer represented him on all of his entities because he never expected Jim Sinicki to carve out the jointly owned entities exception without telling him directly. On the next day, Mark Orr sent this email to Daniel Esposito, which reads in part, "We will be filing the ABS entities in the following order." And he lists the entities that he described as ABS entities. In fact, none of the entities were ABS entities. They were these entities at the bottom of this organizational chart, including those listed in the Exhibit A. These are the same companies for which Snell and Wilmer had just completed the Articles of Incorporation, so they knew they were not ABS entities. They were owned 100% by Will Graven through his holding companies. And this organizational chart, according to the metadata, was created by user Caston B at Snell and Wilmer, which is further evidence that Snell and Wilmer had a very clear understanding of Will Graven's network of companies. So for Mark Orr to refer to these entities as ABS entities is another example of how people sometimes used ABS incorrectly out of habit and convenience and not technical accuracy. On February 16, 2006, Brian Burt continued to work on the new ABS shareholders agreement, billing 6.2 hours he described as review Deborah Debris' employment agreement, Arizona Building Systems Articles of Incorporation in connection with the Arizona Building Systems shareholders agreement, and prepare same. As a reminder, there was no Deborah Debris employment agreement at this time because she had accepted 9.9% ownership in ABS in exchange for voiding that agreement. And now that Brian Burt is finished with his first revision to the ABS shareholders agreement, on February 17th, Bill Caston billed just over an hour and began his review of the agreement. On February 20th, Bill Caston billed almost 2 hours and continued his review. On February 21st, Bill Caston billed 2 hours, continued his review, and discussed the agreement with Brian Burt. And then on February 22nd, Brian Burt billed just over 3 hours, discussed the agreement with Bill Caston, and made some additional changes. And then on February 23rd, Bill Caston billed 1.3 hours and made some additional changes to the agreement prior to sending it to Mark Orr. And then also on February 23rd, Brian Burt billed 0.6 hours, discussed the agreement with Bill Caston, and made some additional changes. All of these changes, which Snell and Wilmer knew to be against Will Graven's interests, were billed to Arizona Building Systems to the attention of Will Graven, President. On February 23, 2006, Mark Orr sent this email to Daniel Esposito and copied Brian Burt. It reads in part, "I am also attaching a draft of the Arizona Building Systems, Inc. S Corporation shareholder agreement. As always, thanks for the work." And attached to the email is a file called Arizona Building Systems Shareholders Agreement.doc. So let's take a quick look at the draft shareholders agreement that was attached to the email. This language identifies one of the purposes of the agreement to limit the manner and terms by which the company's securities may be transferred. Will Graven told me as a 90.1% majority owner, he would not have agreed to any limitations as he didn't feel like he needed to get Deborah Debris' permission to transfer or sell some or all of his securities. This language established the number of directors on the board to be 3 people. One person designated by Will Graven, another by Deborah Debris, and another by mutual agreement of Deborah Debris and Will Graven. Deborah Debris said to me in a subsequent interview that she believes the third person would have been Daniel Esposito. Will Graven said he would have never agreed to this, as Deborah Debris was a silent minority owner who had taken ABS from a profitable company to one near bankruptcy, and Daniel Esposito had very limited experience and had only been with ABS for a few months. However, since Daniel Esposito, Deborah Debris, and everyone from Snell and Wilmer concealed what they were doing from Will Graven, he had no idea that such language was being added. And this is the mechanism through which Deborah Debris and Daniel Esposito would be able to insert themselves into the board and then use that board presence to force Will Graven out of the company, as you'll see on the next page. And then finally, the election of each person set forth below to the office set forth besides the person's name. So just as the draft from Daniel Esposito indicated, Deborah Debris would be vice president and Daniel Esposito would be secretary. Will Graven said he would have never agreed to any of this. And on page 2, this language The removal from office of any person set forth in Section 1E above with cause as defined below upon action from the board. This is the mechanism through which Deborah Debris and Daniel Esposito would be able to force Wilgraven out of the company, because they will later make felonious allegations against Wilgraven, including a written executive team memorandum in which they will accuse Wilgraven of failing to perform his duties for the company, and we'll see that memorandum shortly. And then, just like the draft, we have restrictions on transfers and prohibitions on encumbrances. Wilgraven said he would have never agreed to any of this language. And here's the right of first refusal language to which Wilgraven would have objected. And on page 4, we see restrictions applicable to all transfers. Again, Wilgraven wouldn't have agreed to any of these restrictions. And on page 11, Section 10, protective covenants would require unanimous written consent of the shareholders to do a variety of things, including changing the articles of incorporation, bylaws, or other governing documents of any subsidiary of the company, and everything on this page. These are all actions that would require Deborah Debris' written consent. Wilgraven said he would have never agreed to any of this. And on page 13, Wilgraven couldn't even incur a capital expenditure over a certain amount without getting Deborah Debris' written consent. And then finally, Wilgraven wasn't even allowed to amend this section without Deborah Debris' permission. And as before, when Mark Orr sent this new shareholders agreement, he sent it to Daniel Esposito, copied Brian Burt, and even copied Daniel Esposito's legal assistant, Tracy Lopez, but he didn't copy Wilgraven. And this is staying true to Snell and Wilmer's original plan to go through Daniel Esposito. And the personal relationship between Mark Orr and Daniel Esposito continues to evolve. According to this email, the two of them are planning to go golfing at Legend Trails with Mark Stryker and Greg Smolens. As a reminder, Mark Stryker is the Vice President of Development Services for ABS. He will later conspire with Daniel Esposito and several other ABS executives to form a competing company, and then use ABS intellectual property, personnel, and other resources to pursue millions of dollars worth of ABS leads and projects, all while collecting an ABS paycheck and purporting to Wilgraven that he remained a loyal employee. And Greg Smolens was the Director of Information Technology at ABS, who will later monitor the emails sent to and from Wilgraven, Wilgraven's children, and several project managers, and then forward copies of those emails to the same ABS executives who had formed the competing companies. On February 28, 2006, Deborah Debris sent this email to Daniel Esposito and asked, "What is the latest on receiving the draft copies of the stockholder agreements? Everything is at risk until those are in place. A bit scary with all the flying around Will is doing." This is 2 months after Deborah Debris was supposed to be fully removed from ABS. And now that the ABS shareholders agreement has been modified to enable board members to force shareholders out of the company for cause, we've got this executive team memorandum dated March 1st, 2006, in which the executive team alleged, among other things, that Wilgraven failed to adhere to the advice and direction of his executive team, which resulted in suspect management of finances and overall poor business decisions. So this is the first step in forcing Wilgraven out of the company. And I should point out that on March 1st, 2006, Michael Grode didn't even work for ABS, yet he had already formed an opinion on Wilgraven's business acumen. And as the executive team is putting together the memorandum to force Wilgraven out of the company, Mark Orr, Daniel Esposito, Thaddeus Sabarni, and Mark Stryker plan to go golfing at Marriott Desert Ridge. As a reminder, Ted Sabarni was the Senior Vice President of Operations for ABS, who between January and March of 2006 embezzled approximately $180,000 from the company. Here's a letter from Jim Sinicki to Daniel Esposito on March 6, 2006, with the subject line, "Corporate Entities and Contractors Licensing." The body of this letter really isn't important. What's important is on the final page, where it shows that Jim Sinicki sent a copy to Wilgraven via email and regular mail. So Jim Sinicki continued to copy Wilgraven on some correspondence, but he didn't copy Wilgraven on anything related to the new representation letters that carved out the jointly owned entities exception, or anything related to the modifications to the ABS shareholders agreement. In fact, we took a closer look at the communications between Jim Sinicki and Wilgraven and Daniel Esposito. We did a search for all emails sent from Jim Sinicki or his legal assistant, Don Detjens, to Daniel Esposito, and we have a total of 81 unique results. Out of the 81 emails sent, 33 of those emails excluded Will Graven and 48 included Will Graven. So Jim Sinicki included Will Graven on more than half of the emails he sent, but according to Will Graven, Jim Sinicki never said anything to him about the new engagement letters or the new ABS shareholders agreement. And this is a very important slide. According to this draft billing statement, attorney Bill Kasten billed 0.8 hours on March 27, 2006 for work he described as discussions with Mark Orr regarding org chart and concerns second thoughts of D. Esposito. As we will see on the next slide, the timing for Daniel Esposito's concerns and second thoughts coincides with when Snell and Wilmer will decide to reverse many of the changes to the ABS shareholders agreement. Also, Snell and Wilmer will later edit this draft billing statement to remove this revealing language prior to sending it to ABS. So on the same day that Daniel Esposito expressed his concerns and second thoughts, Brian Burt billed 1.9 hours for work he described as Revise Arizona Building and Development Shareholders Agreement, an email to T. Lopez regarding same. And here's the corresponding email from Brian Burt to Tracy Lopez with a copy to Mark Orr. It was sent on March 27th at almost 11 p.m. The email reads, attached per Urandan's comments is a revised version of the Arizona Building and Development Shareholders Agreement. The email warns, Will is now the sole director and president. You indicated that Deborah will not be an officer or director of the company, nor play any day-to-day management role. And since Will is now the sole director, he, as the board, now has the power in Section 2, Restrictions on Transfer. Strongly consider whether we should modify that section to give Deborah an equal or at least some say over those decisions. Please consider and have Will and Deborah discuss. So it appears now that Snell and Wilmer is looking out for Deborah Debris' interests instead of Will Graven's. And consistent with their plan to go through Daniel Esposito, Brian Burt is directing Tracy Lopez to have Will and Deborah discuss, rather than Brian Burt having the conversation directly with Will Graven. And now on the second page of this email, we have Brian Burt continuing to look after the interests of Deborah Debris by highlighting that the only source of control she's going to have over ABS is through the protective covenants in Section 10. And again, rather than picking up the phone and talking directly to Will Graven, Brian Burt instead relied upon Daniel Esposito's legal assistant, Tracy Lopez, to effectively communicate these legal nuances to Will Graven. And if we look at the header of the email, they again did not include Will Graven. And as soon as Tracy Lopez received this email the next morning at roughly 7 a.m., she forwarded to Daniel Esposito and commented, wow, we really put him to work. Look at the time. On April 4th, 2006, Jim Sinicki's legal assistant, Don Detjens, sent this email to Daniel Esposito and copied Mark Orr and Jim Sinicki. The email reads, Dan, pursuant to your request to Mark Orr, attached are the January and February statements and a draft of the March bill. And she attached the statements to the email. So if we compare the draft March billing statement with the final March billing statement, we see some differences between the entries. On the draft statement, Bill Kasten had the word began and then removed it from the final billing statement. I don't think there's anything remarkable about that change. Brian Burt changed this billing entry. Again, nothing remarkable about that. Here's a new billing entry on March 9th. Again, nothing remarkable about that. On page 2 of the draft, we have the concerns, second thoughts entry that I described earlier. And on the final bill, it's been changed. Instead of concerns and second thoughts, it now reads input of D. Esposito. So at some point after Daniel Esposito reviewed the draft language, someone at Snell and Wilmer decided to remove the language about Daniel Esposito having concerns and second thoughts about the ABS shareholders agreement prior to finalizing the bill and sending it to ABS. This raises the obvious unanswered question. Why change this language at all? Comparing the remainder of the bill, Brian Burt added on March 27th revise Arizona Building and Development Shareholders Agreement and email to T. Lopez regarding same. This entry corresponds to when Brian Burt reversed many of the changes to the shareholders agreement and then emailed the new version to Tracy Lopez at about 11 p.m. on March 27th. This too is very important. Not only did someone at Snell and Wilmer remove the reference to Daniel Esposito having concerns and second thoughts, someone also changed the addressee on this billing statement. Instead of sending it to Will Graven like all the other billing statements, this March billing statement for this one matter is the first and only billing statement up to this point sent to Daniel Esposito. And as before, this email included Mark Orr, Daniel Esposito, and Jim Sinicki, but nobody included Will Graven. So that's a summary of the conspiracy to take over ABS. Next, we'll talk about the failure of Will Graven's companies and the red flag emails that Will Graven discovered. On April 26, 2006, Daniel Esposito sent this email to Mark Orr, which reads in part, "Confidential, on a side note, personally, my position as General Counsel Corporate Secretary is both challenging and nerve-wracking at the same time." And he goes on to ask for his liability if this Will Graven Express goes belly up, and he explains he has no control over the spending of money, and he has no idea what Will Graven spends or misappropriates money on. This is the first of the 4 emails that Will Graven will later describe as red flag emails. On May 1st, 2006, because he had not yet received a response from Mark Orr, Daniel Esposito sent another email to Mark Orr, which reads, "Let me know when you get some information from me regarding my possible dilemma. Thanks." And he signed it sweating like Nixon. This is the second of the 4 red flag emails. On May 15th, 2006, Michael Groh, who by this time had become the chief financial officer for ABS, formed a company called DM3 Associates LLC. The members included Michael Groh, ABS President Mike Martin, Daniel Esposito, and Mark Stryker. DM3 Associates LLC will later be renamed to DSM Development Group LLC to accommodate the addition of another ABS employee by the name of Scott Hess. The investigation confirmed that Mike Martin, Michael Groh, Mark Stryker, Daniel Esposito, and Scott Hess will later use DSM Development Group to pursue millions of dollars worth of ABS projects and leads, all while collecting an ABS paycheck and representing to Will Graven that they remained loyal ABS employees. On May 17, 2006, Snell and Wilmer attorney Mike Donahue finally replied to Daniel Esposito's email regarding his personal liability if the Will Graven Express went belly up. Mike Donahue first gives Daniel Esposito general advice regarding his liability, but then writes, "Snell and Wilmer, as counsel to the company, is not in a position to advise you regarding your personal liability or responsibilities. We encourage you to obtain separate counsel to advise you on those issues." Mike Donahue then added, "As counsel for the company, your emails were very concerning to us. We request that you disclose to us as soon as possible the facts that gave rise to your emails so that we may properly advise the company about remedying any problems." This is the third of the 4 red flag emails. It's also worth noting that Daniel Esposito sent his initial query to Snell and Wilmer on April 26, 2006. So it took Snell and Wilmer about 3 weeks to respond to the allegations that Michael Donahue himself described as very concerning. And then on the same day, May 17, 2006, Daniel Esposito replied to Michael Donahue and copied his friend Mark Orr. His email reads, "I appreciate your response. The source of my emails were purely hypothetical and just a basis for me to be enlightened as to my position." And then he claimed that he explained this to Mark Orr when he first inquired into the matter. This is the last of the 4 red flag emails. So here's an overview of the 4 red flag emails. April 26th, what is my personal liability if ABS and related companies go bankrupt and Will Graven is misappropriating money? May 1st, after not receiving a response to his first email, Daniel Esposito sends another email to Mark Orr asking for help regarding his possible dilemma and signs it sweating like Nixon. May 17th, Michael Donahue from Snell and Wilmer responds and writes, "We can't represent you individually, seek private counsel, but your emails were very concerning. Please provide facts." Daniel Esposito responds immediately, "Never mind, it was only hypothetical." Snell and Wilmer never told Will Graven about these emails. And at the time, Will Graven still believed Snell and Wilmer represented him and had a fiduciary duty to notify him of such an alarming email exchange. That is, he still had no idea that Jim Sinicki, Bill Casta, and Mark Orr decided to work with and through Daniel Esposito to execute their six-step plan to significantly redefine the engagement and introduce, without Will Graven's knowledge, the jointly owned entities exception. On May 17th, which was the same day Daniel Esposito received that email from Michael Donahue, Daniel Esposito drafted this letter to the Arizona Corporation Commission in which he resigned as corporate secretary for ABS, which by this time had been renamed to Arizona Building and Development. Investigators also discovered this email from Snell and Wilmer attorney Barbara McLeod dated July 10th, 2006. In the email, she asked Daniel Esposito for the availability of one of the ABS officers. Daniel Esposito replied, "The only officer is Will, since as per our conversation not too long ago, I followed your advice." This email indicates that Snell and Wilmer attorney Barbara McLeod had advised Daniel Esposito to resign his position as corporate secretary, yet no one told Will Graven that Snell and Wilmer had advised Daniel Esposito to take such action. Had they told Will Graven that Daniel Esposito was resigning from his position as corporate secretary, it would have at least put Will Graven on notice that Daniel Esposito was purporting to be corporate secretary. But according to Will Graven, no one from Snell and Wilmer ever advised him of what Daniel Esposito was doing. Moving forward in the timeline, after the executive team started DM3 Associates LLC, which was later renamed to DSM Development Group, the executive team used ABS intellectual property, personnel, software, and other resources to pursue more than a dozen projects worth more than $100 million. These employees didn't leave ABS to form this competing company. They stayed at ABS, continued to collect an ABS paycheck, and continued to represent to Will Graven that they remained loyal ABS employees. On November 3, 2006, Daniel Esposito sent this email to Michael Groh and Mike Martin, which reads, "Cash those checks. Be prepared to rape and pillage the office next week for everything we can get. I figure I will knock out Dave Harrington and chase everyone else out of the office, then out the back door with every printer, copier, computer, etc., and off to DSM." Dave Harrington was an ABS employee who was also a friend of Will Graven's. On December 31st, 2006, Daniel Esposito, Michael Groh, and Mike Martin exchanged an email which reads, in part, "We gotta fuck this guy." And the context of this email makes it very clear that they were referring to Will Graven. On the same day, New Year's Eve, Daniel Esposito, Michael Groh, and Mike Martin exchange another email where Daniel Esposito writes, "Man, this is gonna be good. 1, 2, 3, 4, fuck the Graven." Investigators interviewed Monica Chanel Flores, who was an ABS employee who sat near the shredder. According to her statement, between December 2006 and February 2007, she saw Michael Groh, Michael Martin, but mostly Daniel Esposito, constantly overfilling the shredder. She indicates that in one particular week they had to empty the shredder container 3 times, which is why it caught her attention. During a subsequent free talk with Michael Groh, who, as I mentioned, is now cooperating, he admitted that he destroyed job cost reports and that he observed Daniel Esposito shred thousands of unidentified documents for unknown reasons. Will Graven provided investigators with a copy of this color-coded index that appears to reference several documents. He said he found it in the desk of Rose Campos, who was Daniel Esposito's legal assistant at ABS. Investigators interviewed Rose Campos, and she confirmed she did indeed create this index and that it referred to the documents in Daniel Esposito's filing cabinet. You can see that there's a section titled Snell and Wilmer, and that it goes on for several rows in this index, which, by the way, is about 50 pages long, and according to Will Graven refers to tens of thousands of pages of documents. Unfortunately, all these documents are now missing. Will Graven believes either Daniel Esposito shred them or took them with him when he left ABS. In late January 2006, the ABS executive team forged several documents resulting in losses of $200,000. They used $29,000 in ABS funds without authorization to purchase a personal use 2006 Ford Expedition. They also worked with the Director of Information Technology, Greg Smolens, to monitor emails to and from Will Graven, to and from his children, and to and from several project managers. They received approximately $90,000 in excess income by processing raises for each other without authorization. They stole construction rubble worth about $85,000. They worked with officials from the city of Victorville to forge a contract that resulted in losses of $8.5 million. They used ABS funds and credit to purchase a 2007 Pontiac Solstice for Mike Martin, which he took with him when he left ABS. This vehicle was later repossessed when the ABS bank accounts ran out of money and the automatic payments failed. One payment was even deducted directly from Wilgraven's personal account. They started yet another competing company called Commercial Steel Systems and then continued to use ABS intellectual property to pursue millions of dollars in ABS leads for the benefit of Commercial Steel Systems. Esposito resigned without notice, and when he left, took with him several bankers' boxes full of documents and destroyed others. Collectively, this is what the executive team referred to when Daniel Esposito wrote in an email that it was time to rape and pillage the office. Moving forward in the timeline, on February 12, 2007, Daniel Esposito, Michael Groh, and Mike Martin exchanged these emails using their Commercial Steel Systems email accounts. Mike Martin wrote, "Clowns to the left of me, retards to the right. Here I am stuck in the middle with Will. As I look forward to the upcoming week, I know I have been left behind for a reason. I am to cover our tracks and assure our success. You both suck and I will pay you back." Michael Groh replied, "We love you too." And Esposito replied, "Ditto. Hey Mike, break out the beers. Party." The investigation confirmed that the idea to leave someone behind at ABS to cover their tracks and assure their success originated as early as June of 2006, after Bill Casta and Mark Orr learned that Daniel Esposito had concerns and second thoughts about the changes to the ABS shareholders agreement. And now here we are in February of 2007, and Mike Martin is still purporting to work at ABS. Just after this email, Mike Martin stopped showing up for work. He provided Wilgraven with different excuses about his kids being sick or him being sick from his purported cancer treatments. And then finally, in mid-March of 2007, Mike Martin dropped off his BlackBerry and said he would not be back. In about June of 2007, all of Wilgraven's companies went out of business. He estimates his losses due to the failure of all those companies, all their projects, and the loss of other assets is in excess of $200 million. Finally, in July of 2007, Wilgraven discovered the third and fourth of the 4 red flag emails. He hadn't discovered the first and second yet, so he didn't know what Michael Donaghy was describing as very concerning. Upon discovering these 2 emails, he walked into Snell and Wilmer and confronted Jim Sinicki. Jim Sinicki reviewed the emails and said they weren't conclusive, but even if they were, Jim Sinicki said Snell and Wilmer had no duty to report anything to Wilgraven because he wasn't their client. At the time, Wilgraven was completely confused by such a statement, but feeling helpless to prove otherwise, he left. It wasn't until February of 2011 that Wilgraven discovered the first and the second of the 4 red flag emails. Upon discovering these emails, he wrote a letter of demand to Jim Sinicki dated February 26, 2011. The letter reads, "As you will recall, I brought to your attention what was an obviously red flag communication that I had uncovered between certain of your firm's attorneys and my in-house general counsel, Daniel Esposito, who was also my personal attorney, as you know. I was not informed by your firm of this red flag communication, and I asked you why not. You and I discussed this matter, and then you introduced me to a partner of yours. You both said that as I was not your client, but that my company was, you had no professional responsibilities with nor owed any duties to me personally. When I spoke with Mark Orr, he claimed the same thing. At that time, I believed you, your partner and Mark, as I knew less than nothing about such matters, and I respected and trusted you and the good name of your firm, which is, of course, why I retained you in the first place. I now know better. You and your firm knew better. You knew how extensively you had represented my multiple companies and me, and you knew the responsibilities and duties you owed me." On the second page, Wilgraven indicated that if Snell and Wilmer had done their jobs and notified Wilgraven about the emails, it could have prevented catastrophic losses. He estimated his losses at $250 million and claimed Snell and Wilmer's poor decisions were in part due to the close personal friendship that had evolved between Daniel Esposito and Mark Orr. And as an example of that friendship, he reported what Wilgraven learned after his companies went out of business, that Daniel Esposito provided Snell and Wilmer with 12 tickets to the Madonna concert at the EBS Suite. Wilgraven added that he was prepared to file a $250 million lawsuit against Jim Sinicki and the firm, but before doing so, he asked Jim Sinicki to work with Snell and Wilmer's malpractice insurance carrier and offer him a settlement instead. According to Wilgraven, Jim Sinicki never responded to the letter of demand, so Wilgraven filed a civil lawsuit. This lawsuit was limited to the 4 red flag emails that had nothing to do with the conspiracy to take over ABS. The conspiracy to take over ABS wasn't discovered until 2014. On June 13, 2011, Wilgraven filed a civil lawsuit against Jim Sinicki, Mark Orr, Mike Donahue, and Snell and Wilmer for 15 separate causes of action related to the red flag emails. The entire complaint is more than 370 pages, including more than 300 pages of exhibits. By the time Wilgraven filed this lawsuit, he had already been looking through corporate records and emails for several years, since about June of 2007, all in an effort to better understand why his companies had failed. He found thousands of emails and other documents that showed the ABS executive team committed multiple acts of forgery, theft, fraud, and computer tampering. And as I mentioned earlier, those allegations are the focus of separate investigations, which have already led to more than 80 felony charges. While Wilgraven had access to thousands of emails and documents, he was still missing several key pieces of evidence, so his understanding remained fragmented and incomplete. He was also so focused on proving that Snell and Wilmer had a fiduciary duty to protect his interests that he didn't fully understand the significance of many of the documents he had found. For example, at some point, Wilgraven found this December 14, 2005 email from Daniel Esposito to Bill Kasten, in which Esposito first asked for the changes to the shareholders agreement. Wilgraven even included a copy of this email in his complaint as Exhibit 18. However, because he was focused on proving only that Snell and Wilmer had a fiduciary duty to notify him of the red flag emails, if we look at the body of the complaint, we can see that he used the exhibit only to show that Snell and Wilmer was in fact representing him by forming so many companies. He didn't notice at the time that the email also shed considerable light on the conspiracy to take over ABS. At some point, Wilgraven had also discovered this December 14, 2005 email from Bill Kasten to Daniel Esposito, in which Kasten wrote, "I think you and I should meet prior to my meeting with Will to make sure that we are on the same page." Just like the previous example, Wilgraven also included a copy of this email in his complaint as Exhibit 20, and again, because at the time he was focused on proving only that Snell and Wilmer had a fiduciary duty to notify him of the red flag emails, he used the entire email to show that Snell and Wilmer was in fact representing him by providing legal advice on his network of companies. The idea that Daniel Esposito and Bill Kasten would meet to make sure they were on the same page by itself was not alarming to Wilgraven at the time. He thought they were meeting to clear up any confusion that may have existed related to Snell and Wilmer's representation of Wilgraven in the context of his expanding network of companies, some of which Deborah Debris owned 9.9%. However, now, when seen in the context of the conspiracy to take over ABS, the first sentence in this email makes an entirely different impression. At some point, Wilgraven even discovered an unsigned copy of the representation letter that Jim Sinicki wrote on January 4, 2006 and sent to Daniel Esposito. This is the letter we saw earlier in which Jim Sinicki rewrote history and falsely stated that Snell and Wilmer didn't represent Wilgraven. Wilgraven even included a copy of this letter in his complaint as Exhibit 22. If we look at the section of his complaint in which he referred to the letter, we see he wrote, "By January 4, 2006, Defendant Sinicki was expressing his concern and confusion over the various representations that Snell and Wilmer had undertaken over the preceding few months. It's apparent that when Wilgraven filed his lawsuit, he didn't fully understand the significance of this letter. He now believes if he knew at the time that Jim Sinicki prepared this letter only after Daniel Esposito asked him to change the shareholders agreement, he would have interpreted this letter very differently." At some point, Will Graven also discovered this January 12, 2006 email from Bill Kasten to Daniel Esposito, Mark Orr, and Jim Sinicki. This is the email we saw earlier in which Bill Kasten first reiterated what Jim Sinicki wrote in his letter about their plan to go through Daniel Esposito, and then provided a summary of the six-step plan. Will Graven even included a copy of this email in his complaint as Exhibit 24, and if we look at the body of the complaint, we can see how he interpreted this email at the time. Will Graven first wrote, "By January 12, 2006, Snell and Wilmer was bringing additional clarity to the various representations, separating the various entities and establishing separate representation." And then he referred to paragraph 1 in the email, which addressed the jointly owned entities. Will Graven was trying to show that Snell and Wilmer had been representing him on multiple entities. Next he wrote, "By January 12, 2006, Snell and Wilmer was bringing additional clarity to the various representations by agreeing to also represent other entities which are owned entirely by Will Graven." And then he referred to paragraph 2 in the email, which addressed the Graven-owned entities. Next, Will Graven wrote, "By January 12, 2006, Snell and Wilmer was bringing additional clarity to the various representations, declaring it would not represent either Will Graven or Deborah Debris in personal matters." And then he referred to paragraph 3 in the email. This paragraph actually indicates that Snell and Wilmer wouldn't represent Will Graven or Deborah Debris personally on any corporate matters, but this wasn't clear to Will Graven at the time because it contradicted what he believed to be true, that Snell and Wilmer did represent him personally on corporate matters. Now keep in mind, we're talking about Will Graven's interpretation of these documents in June of 2011 when he filed the civil lawsuit against Snell and Wilmer for the red flag emails. He never saw these documents more than 5 years earlier in 2006 when Daniel Esposito and Deborah Debris first conspired with Snell and Wilmer to try to take over ABS. Next, Will Graven wrote, "By January 12, 2006, Snell and Wilmer was bringing additional clarity to the various representations, declaring it would represent Will Graven in personal, non-corporate matters." And then he referred to paragraph 4 in the email, which indicates Snell and Wilmer would represent Will Graven personally on non-corporate matters. When Will Graven filed his lawsuit, he was trying to emphasize that Snell and Wilmer had been representing him and had developed a fiduciary duty to notify him about the red flag emails. At the time, he knew nothing about the conspiracy to take over ABS, so he saw this email in an entirely different light than he does today. At some point, Will Graven also discovered this January 19, 2006 email from Bill Kasten to Daniel Esposito and Jim Sinicki. This is the email in which Bill Kasten provided Daniel Esposito with an update regarding the timing for the new engagement letters. Will Graven included a copy of this email with his complaint as Exhibit 25, and if we look at the body of the complaint, we can see how he interpreted this email at the time. First, Will Graven wrote, "By January 19, 2006, Snell and Wilmer had drafted separate engagement letters for each individual entity and party, including Will Graven for personal matters, but not so for Deborah Debris, who had her long-time personal representation." And by personal representation, Will Graven was referring to Deacon C.D. McDonald, Yetwin, and Lacey. Then Will Graven referred to the part of the email that described Jim Sinicki's plans to review the engagement letters. Next, Will Graven wrote, "By January 19, 2006, Snell and Wilmer held discussions with Deborah Debris to make certain that she understood Snell and Wilmer would also be representing Will Graven in substantially more corporate activity than her, and in Will Graven's personal matters." And then he referred to the part of the email that described Jim Sinicki's discussions with Deborah Debris. This interpretation is consistent with what Will Graven believed at the time, that Snell and Wilmer represented him on corporate activity and on personal matters such as estate and premarital planning. More than 5 years after the fact, Will Graven still had no idea that Snell and Wilmer had worked with and through Daniel Esposito to carve out the jointly held entities exception. And as we'll see later, Snell and Wilmer will wait until November 2, 2011, after the civil case is dismissed, to provide Will Graven with a copy of the engagement letter that reveals the jointly held entities exception. At some point, Will Graven also discovered this January 24, 2006 email from Bill Kasten to Daniel Esposito, Jim Sinicki, Mark Orr, and Mark Bond. This is the email we saw earlier in which Bill Kasten wrote, "Once Deb, Will, and you sign each of the letters, I can get started on the documents." Will Graven included a copy of this email with his complaint as Exhibit 27, and if we look at the body of the complaint, we can see how he interpreted this email at the time. First, Will Graven wrote, by January 24, 2006, Defendant Sinicki had completed and signed, on Snell and Wilmer's behalf, the various separate engagement letters for each individual entity and party, Wilgraven only, for personal matters. And then he referred to the part of the email that read, Jim has completed and signed the various letters. Next, Wilgraven wrote, by January 24, 2006, Defendant Sinicki had completed and signed, on Snell and Wilmer's behalf, letters for each individual party, Wilgraven and sometimes Deborah Debris, clarifying who Snell and Wilmer represented, Wilgraven only, for personal matters. And then he referred to the part of the email that read, other letters to Will and Deborah clarifying who we represent. When Wilgraven filed a civil lawsuit in 2011, he still didn't know, nor could he have known, the significance of the last sentence in this email. At the time, he was only trying to prove to the court that in 2005 and 2006, Snell and Wilmer had developed a fiduciary duty to notify him of the red flag emails. At some point, Wilgraven also discovered this email dated February 23, 2006. This is the email we saw earlier in which Mark Orr sent the draft of the new ABS shareholder agreement to Daniel Esposito, Brian Burt, and Tracy Lopez. Wilgraven included a copy of this email with his complaint as Exhibit 39. If we look at the body of the complaint, we can see how he interpreted this email at the time. Wilgraven wrote, by February 23, 2006, as evidenced by an attachment to this March 8 email, another Snell and Wilmer attorney from their Phoenix, Arizona office, Brian Burt, also began to work for Wilgraven and his companies, and then it referred to the part of the email that shows Brian Burt was copied. I should clarify that Wilgraven found this email attached to a March 8th email, which is why he described it the way he did. So the only reason Wilgraven included this email in his lawsuit was to show that an additional Snell and Wilmer attorney, Brian Burt, also worked for Wilgraven and his companies, again to prove to the court that Snell and Wilmer had developed a fiduciary duty to tell him about the red flag emails. Since that was his primary focus, he didn't at the time scrutinize the shareholders agreement that was attached to the email, which we reviewed in detail earlier in the presentation, the first page of which Wilgraven also included in his complaint. He now believes had he looked at the agreement more closely when he first filed his lawsuit, he would have quickly noticed that the changes were against his interests. It might appear at this point that Wilgraven missed a lot of warning signs in 2011, but we have to keep in mind what he was going through between 2007 and 2011. All of his companies had failed. He was personally bankrupt. He was representing himself on more than a dozen lawsuits against his executive team. He lived out of his car for several months, all while trying to review hundreds of thousands of emails and other documents to piece together why his companies had failed. It's understandable that he missed a few things, especially in light of the fact that it's taken our office about 4 years to get to this point, and we're still not finished. On July 1, 2011, Snell and Wilmer attorney Lisa Coulter, representing Snell and Wilmer, filed this motion to dismiss. Page 2 of her motion reads, ABS was a corporate client of Snell and Wilmer. While Wilgraven held an interest in ABS, Snell and Wilmer did not represent him with respect to any of the corporate entities and therefore owed no legal duties to him individually in terms of the services and advice provided to ABS or its affiliates. And on page 3 it continues, and Snell and Wilmer made it clear in writing that Snell and Wilmer represented only the corporate entities and did not and would not represent plaintiff or other shareholders individually with respect to the corporate matters. And she cites exhibits 22 and 24. If we look at the exhibits, we see that exhibit 22 is the January 4th representation letter that Jim Sinicki sent to Daniel Esposito. We've seen this letter a few times before. It's the one that rewrites history, falsely claims that Snell and Wilmer doesn't represent Wilgraven, and then blindly assumes that Daniel Esposito had obtained all the required approvals. Exhibit 24 is the January 12th email from Bill Caston to Daniel Esposito, in which Bill Caston continues with Snell and Wilmer's plan to go through Daniel Esposito and then explains their 6-step plan to write new engagement letters. What's interesting about her choice of exhibits is that she has in her possession the January 23rd engagement letter, the one that Daniel Esposito tricked Wilgraven into signing that introduced the jointly held entities exception, but for some reason she decided not to use it. Instead, she just referred to the exhibits that Wilgraven had included in his complaint. It's not clear at this point if Lisa Coulter knew the true history and scope of Snell and Wilmer's engagement with Wilgraven, or if for some reason she questioned the authenticity of the January 23rd engagement letter, but why she decided not to use it in her motion to dismiss is an unanswered question. And as we'll see later, she'll wait until November 2nd of 2011, after the civil case is dismissed, to provide Wilgraven with a copy of that engagement letter, revealing to Wilgraven for the first time a document with his signature that reveals the jointly held entity's exception. On January 12, 2011, Wilgraven served Snell and Wilmer with a subpoena requesting copies of all engagement letters and other communications related to engagements between Wilgraven and any Graven-affiliated company. Wilgraven wanted these documents to further prove to the court that Snell and Wilmer did indeed have a fiduciary duty to him. Wilgraven also asked for all emails associated with the red flag emails. Wilgraven said he wanted the information by July 27, 2010, which is obviously an error, as he meant July 27, 2011. On the same date that Wilgraven served Snell and Wilmer with a subpoena for documents, he also served Snell and Wilmer with a subpoena to depose Jim Sinicki, Michael Donahue, Mark Orr, Bill Caston, and Mark Vaughn. On July 27, 2011, Attorney Lisa Coulter filed this motion for protective order and motion to accelerate ruling on same. She provided as one of her three reasons for the motion, there exist unresolved issues of standing and privilege that must be addressed prior to any deposition testimony being given or the production of any documents. And then on page 2, she claims Wilgraven lacks standing to assert the claims he brought in his complaint. And now on page 3, she writes, due to the well-established legal distinction in Arizona between corporate entities and individuals, she challenges whether Wilgraven even has standing to assert the claims based on alleged communications between Snell and Wilmer and its client, ABS, given that 1, ABS was a corporate client of Snell and Wilmer, and 2, while plaintiff held a partial interest in ABS, Snell and Wilmer did not represent plaintiff with respect to any of the corporate entities and therefore owed no legal duties to plaintiff individually. Her use and emphasis of the word partial here is a little misleading in that it fails to convey that Wilgraven's partial interest was actually a significant majority interest of 90.1%. She appears to be attempting to equate the standing that one minority shareholder might have in a large multinational publicly traded corporation with thousands of shareholders to the standing that Wilgraven might have as a 90.1% significant majority owner in a small and privately held entity such as ABS. And Lisa Coulter continues to repeat the same misleading claim that Snell and Wilmer did not have any fiduciary duty to Wilgraven with respect to ABS because he was not the client. Again, it's not clear if Lisa Coulter was intentionally misleading the court when she filed this motion, or if Jim Sinicki, Mark Orr, and Bill Caston simply failed to disclose to her the true history and scope of Snell and Wilmer's engagement with Wilgraven. And then on page 9 of the motion, Lisa Coulter included this statement of moving counsel, which reads, moving counsel certifies that after personal consultation with plaintiff and good faith efforts to do so, counsel have been unable to satisfactorily resolve whether discovery should be stayed in this matter. Those efforts include personal discussions by telephone between undersigned counsel and plaintiff on July 22nd, 26th, and 27th. Wilgraven recalls speaking with Lisa Coulter several times during which he pleaded with her to give him copies of his client files, but each time Lisa Coulter refused, stating that he was not the client and that ABS needed to first give Snell and Wilmer permission to release the files. Wilgraven told her repeatedly that he was a 90.1% owner of ABS and was giving Snell and Wilmer permission. However, according to Wilgraven, Lisa Coulter just kept repeating the same thing over and over again and refused to provide the files. Today, Wilgraven strongly disagrees with Lisa Coulter's characterization that her behavior was a good faith effort. On July 29, 2011, Wilgraven filed this response to defendant's motion for protective order. Investigators have carefully reviewed this response and in particular have reviewed Wilgraven's claims related to the history and scope of his engagement with Snell and Wilmer, and investigators have determined that his claims are indeed supported by all the documentary evidence which, as seen in this presentation, details the genesis and evolution of his engagement with Snell and Wilmer and largely contradicts Lisa Coulter's claims that Wilgraven was not Snell and Wilmer's client. On August 3, 2011, the court granted Snell and Wilmer's motion for protective order. On September 9, 2011, there was a hearing on Snell and Wilmer's motion to dismiss. Lisa Coulter described the first red flag email as, "Hey, Snell and Wilmer, you're ABS outside counsel. I'm general counsel. What is my liability as general counsel for ABS? Can you please advise me on this?" This is a very misleading characterization of the first red flag email. Lisa Coulter neglected to say that Daniel Esposito marked his email confidential, that he accused Will Graven of misappropriating funds, and that Daniel Esposito was concerned about his liability if and when Will Graven's companies went bankrupt. During the same hearing, Lisa Coulter also described the third red flag email as, "Your liability as general counsel for ABS is generally this. If you need something more specific, you need to go out and get individual counsel because we represent ABS and we can't advise you in your individual capacity as counsel for ABS." This, too, is a very misleading characterization of the third red flag email. Lisa Coulter neglected to say that Michael Donahue described Daniel Esposito's earlier email as very concerning. She also failed to say that Michael Donahue asked Daniel Esposito to provide the facts that gave rise to his email so that Snell and Wilmer could properly advise the client. At the same hearing, she didn't even mention red flag emails 2 or 4. According to Will Graven, after this hearing, he asked Lisa Coulter for copies of his personal files at Snell and Wilmer, which related to his estate and premarital planning, and according to Will Graven, Lisa Coulter agreed to provide him with the documents. This is September 9th, 2011, and as we'll see going forward in the presentation, Lisa Coulter will not provide these documents until June 15th, 2012, after the case is dismissed, and she'll later claim that she didn't recall ever being asked. And to be clear, we're only talking about the files related to Will Graven's estate and premarital planning, his personal affairs. We're not talking about the corporate files related to all of Will Graven's companies. She'll never provide the corporate files to Will Graven. In fact, when investigators sent a subpoena to Snell and Wilmer to get copies of all files related to Will Graven and his companies, Snell and Wilmer refused and claimed, even to law enforcement, that since Will Graven was not the client, he could not waive privilege. We had to obtain a court order before Snell and Wilmer would finally release the files to investigators. And as we'll see later, several important documents were missing. On October 13th, 2011, which was approximately 1 month after the hearing, Will Graven sent this email to Lisa Coulter, which read, "I have not yet received copies of my personal engagements with your firm, as you told me some several weeks ago that you would provide." The next day, Lisa Coulter replied to Will Graven and wrote, "I do not recall the prior discussion to which you are referring. I will be happy, however, to pull the files and evaluate your request. Given the age of the file, I believe it would be in off-site storage and may take me a few days to retrieve. I will be in contact with you next week." What's interesting about Lisa Coulter's response is that she appears to agree to provide Will Graven with copies of his documents, but in fact, she only agreed to pull the files and then evaluate Will Graven's request for the files. Will Graven replied, "Thanks, Lisa. I look forward to your call. Thank you. Make it a great weekend." On October 26, 2011, the court issued a ruling on Will Graven's civil case. On page 2 of the ruling, the court dismissed counts 1, 2, 3, 4, 5, 8, 9, 10, 11, 12, and 14 due to statute of limitations. On page 3, the court dismissed counts 7 and 13 and asserted that Will Graven had failed to identify the specific contract or agreement that was allegedly breached. The court gave Will Graven 30 days to file an amended complaint for these 2 counts only. And at the bottom of page 3, the court also dismissed count 15, asserting that the rules of professional conduct cannot form the basis for civil liability. And then on November 28, 2011, the court amended its earlier ruling and dismissed count 6 as well due to statute of limitations. So at this point, approximately 5 months after Will Graven first filed his lawsuit, all of his allegations were dismissed, and Snell and Wilmer still had not provided any copies of any documents, not even the documents associated with Will Graven's personal engagements. So now on October 30th, 2011, Will Graven followed up on his previous request for copies of his documents and sent another email to Lisa Coulter that reads, 2 weeks have passed since your last email. Almost 3 months have passed since you first agreed to provide the requested documents. This is starting to smell like obstruction of justice. And he writes postscript, no one would believe you have not had my personal file on your desk since the beginning of this case. How could you have made certain of the representations you have without first reviewing my personal engagements with your firm? I tend to agree with Wilgraven's assessment here. If Lisa Coulter is going to represent Snell and Wilmer in this civil lawsuit, which had gone on for 5 months, it makes sense that she'd already have convenient access to these documents. So now on October 31st, 2011, after all of Wilgraven's allegations were dismissed, Lisa Coulter sent this email, which reads, this email is in response to your several emails over the past few days. As I indicated, I have no recollection of a discussion several weeks ago in which I agreed to forward to you the retention letter regarding your personal representation on estate planning matters. While I did receive an email a couple of weeks ago requesting that letter, I informed you at that time, given the age of the file, it was in off-site storage. The file was not, as you suggest, in my office, since your personal or estate planning file has no relationship to the allegations in the current complaint. I requested the file after your email and had the chance to review it last week. While a retention letter was sent to you on January 27, 2006, we have no record of you signing or returning the letter. I therefore am enclosing a copy of the letter that was sent to you. Attached to the email was a file titled retainerletter.pdf, which was a copy of the retainer letter we saw earlier dated January 27, 2006. That was for Wilgraven's estate and premarital planning, which Wilgraven never signed. What's interesting about Lisa Coulter's email is, even though Wilgraven had been asking for copies of his entire file, she responded by writing that she had no recollection of a discussion in which she agreed to forward the retention letter. So she's unilaterally narrowing the scope of what Wilgraven had requested to just the engagement letter, and then she provided only that, the engagement letter. Then a few days later, on November 2nd, 2011, Lisa Coulter sent this email, which reads, the only other letter I've been able to find, in addition to those attached to your complaint, is attached. It does not relate to the firm's retention by you on an estate or personal matter. Rather, it confirms that, in connection with the firm's representation of the corporate entities, it will not represent your personal interests. If we look at the attachment, we see it's the January 23rd engagement letter that Daniel Esposito tricked Wilgraven into signing that introduced the jointly held entities exception. More than 5 years after Jim Sinicki wrote this letter, someone from Snell and Wilmer finally sent it directly to Wilgraven. This is the first time Wilgraven ever saw this engagement letter, and unfortunately, since all of his allegations against Snell and Wilmer had been dismissed, he didn't pay much attention to it at the time. Wilgraven now believes this is exactly what Lisa Coulter was hoping for, and the reason she didn't provide it earlier. And this is the engagement letter to which I referred earlier when I questioned why Lisa Coulter didn't include it in her motion to dismiss. This letter allowed Snell and Wilmer to change the shareholders' agreement. It was in Snell and Wilmer's files. She had access to it from the beginning, but for some reason she decided not to use it in her motion to dismiss and instead relied entirely upon the exhibits that Wilgraven included within his complaint. On June 13, 2012, Wilgraven prepared this preservation letter, which reads, I first asked you for my files and those of my companies late last July 2011, to which you agreed to provide such, but noting that it would take some time to gather these materials. I have asked you about this on various occasions since, to which you have stated it was taking longer than anticipated. Your delay in providing my files is nothing less than obstruction of justice and is a continuation of your pattern of unethical behavior. Please do the right thing this time, starting again from the beginning. And then Wilgraven asked Lisa Coulter to preserve his files and asked her again to provide him with copies of all records related to his personal and corporate engagements. On June 15th, Lisa Coulter acknowledged receipt of Wilgraven's preservation letter. And then on the same day, Lisa Coulter responded to the letter writing, I do not recall prior requests for your copies of your personal files or corporate files. We are pleased, however, to respond to your current request. With the letter, she included copies of 31 pages of documents related to Wilgraven's personal estate planning. However, with regard to Wilgraven's request for corporate documents, she wrote, as to the corporate files, we are still involved in active litigation with you as a result of the lawsuit you filed against Snell and Wilmer. We therefore are not in a position to release the files to you at this time. And then she invited Wilgraven to come into her office to review the files, which she indicated consists of thousands of documents. I should clarify that even though all of Wilgraven's allegations had been dismissed, Wilgraven had 30 days to file an amended complaint, so the court had not yet issued a final judgment. On June 29, 2012, Wilgraven sent this email to Lisa Coulter, which reads, "Your letter and argument are further evidence of your fraudulent ways, and I will use them as such. My companies have not filed a complaint against you. I have. I am in litigation against your clients. My companies are not. My request has nothing to do with discovery. You should have delivered my materials months ago when I first requested them. Please immediately prepare and deliver my materials as requested, as you are ethically bound to do." More than 3 weeks later, Lisa Coulter responded to Wilgraven's email, writing, "Upon receipt of your initial letter, we forwarded to you copies of the file that was opened to handle your personal trust and estate work. As to the corporate files, it is apparent that we do not agree as to the nature of your lawsuit against Snell and Wilmer. The files, however characterized, are necessary to Snell and Wilmer's defense of the claims asserted in your complaint. As the matter is still pending in the courts, Snell and Wilmer must continue to have access to and retain the original files," and she repeats her offer to have Wilgraven go into the Snell and Wilmer office to review the documents. On January 16, 2013, Lisa Coulter filed a motion for entry of final judgment. Wilgraven had not yet amended his complaint by the date set by the court, so on February 21, 2013, the court dismissed all of Wilgraven's allegations with prejudice. On May 31, 2013, Wilgraven filed an appeal with the Arizona Court of Appeals, and on February 18, 2014, it affirmed the lower court's decision. On March 18, 2014, Wilgraven filed a petition for review with the Arizona Supreme Court, and on July 7, 2014, the Arizona Supreme Court denied review. On October 6, 2014, Wilgraven filed a petition for review with the United States Supreme Court. On November 26, 2014, his petition was distributed for conference, and on December 15, 2014, his petition was denied. So that's an overview of the civil lawsuit and subsequent cover-up. Now I'm going to take just a few minutes to summarize the investigation. Since 2012, we've executed several search warrants at the homes of many of the ABS executives, during which we seized several computers and other digital storage devices. We also recovered several ABS computers, servers, and hard drives from former ABS employees who have assisted us in the investigation. In total, we collected 208 digital storage devices, which translates roughly to 10 terabytes of data. From that 10 terabytes of data, we recovered more than 180,000 unique emails and hundreds of thousands of other documents, which collectively helped us to better understand what happened. For example, this December 14, 2005 email from Esposito to Debris, where he's letting her know that he sent the modifications to Snell and Wilmer for their review. The "Which are Deb's concerns" email from Bill Caston. The "I don't want to say I told you so" also from Bill Caston. The email from Deborah Debris regarding her middle-of-the-night thoughts. These are all emails I presented earlier, so they should be familiar. This one from Daniel Esposito to Mark Orr: "You are my friend foremost as well as my colleague." This one from Deborah Debris, where she writes, "Everything is at risk until the new shareholders agreement is in place." Deborah Debris signing the one check to Snell and Wilmer, and then the draft of the Snell and Wilmer invoice from March of 2006 that references Daniel Esposito's concerns and second thoughts. These emails and other documents caused us to take a closer look at the documents Wilgraven already had in his possession, the ones he included in his civil complaint, but hadn't yet read them carefully. For example, the December 14, 2005 email from Daniel Esposito to Bill Caston, in which he first asked for the changes to the shareholders agreement. The draft version he included with the email. This one from Bill Caston to Esposito, where he suggested meeting to make sure they were on the same page. This one from Bill Caston to Esposito about Jim Sinicki meeting with Deborah Debris to review the engagement letters. The January 4, 2006 representation letter from Jim Sinicki to Daniel Esposito. This is the one where Jim Sinicki falsely claims that Snell and Wilmer does not represent Wilgraven. This email from Bill Caston, where he's waiting for the new engagement letters to be signed prior to making any changes to the shareholders agreement. and then the February 23rd email from Mark Orr that contained the draft shareholders agreement. All of the new documents we found, plus a new perspective on the old documents, made it clear that we needed copies of Snell and Wilmer's internal client files for Wilgraven and his companies. So on September 10th, 2014, Wilgraven signed this privilege waiver, and we served Snell and Wilmer with a subpoena for all documents in their files related to Wilgraven. Snell and Wilmer attorney Lisa Coulter, who, as I mentioned earlier, represented Snell and Wilmer during Wilgraven's civil lawsuit and refused to provide Wilgraven with copies of his client files. Well, on September 26, 2014, she came to the Attorney General's office to discuss the subpoena, and during our meeting, she said Wilgraven didn't have standing to waive privilege because he wasn't Snell and Wilmer's client. So now, almost 10 years later, we find Snell and Wilmer continuing to stand by the new version of history that Jim Sinicki had created back in January of 2006. It wasn't until our office obtained a court order that Snell and Wilmer finally provided us with the documents. And on November 19th, 2014, delivered those documents to our office on this CD. As you can see by the Bates numbers, it contains more than 15,000 pages of documents. When we examined the contents of this CD, we found the six-step plan, which, as you can see, is Bates numbered 7909. Immediately after the six-step plan on the CD, we found the handwritten notes, Bates 7910. We also found the email in which Daniel Esposito first directed Bill Kasten to form more than 27 single-member LLCs for Wilgraven. You can see that's Bates 7911 through 7913. And then Bates 7914 is the December 14th, 2005 email from Esposito to Kasten in which he first asked for the changes to the shareholders agreement. Based on the header and footer of these documents, Bill Kasten printed them on December 21st, 2005. So even though the handwritten notes aren't dated, they were provided on the CD immediately adjacent to the documents Bill Kasten printed just prior to the January 4th, 2006 meeting. And as a reminder, that's the date on which Jim Sinicki had a teleconference with Daniel Esposito, and Jim Sinicki, Mark Orr, and Bill Kasten met to discuss the org chart and representation. So these facts are consistent with the handwritten notes and six-step plan being produced during the January 4th meeting. What's more interesting than the documents we found on the CD are the documents we didn't find on the CD. This is the December 14th, 2005 email from Esposito to Kasten in which he first asked for the changes to the shareholders agreement. Recall that Daniel Esposito included his draft of the shareholders agreement as an attachment. While you've not been able to find the attachment to this email on the CD from Snell and Wilmer, we looked at 10 other randomly selected emails on the CD that included attachments, and all 10 attachments were also located on the CD, so it's not clear why the attachment is missing from this particular email. And these emails, I don't want to say I told you so, and which are Deb's concerns or are all of them Deb's concerns, were also not found on the CD from Snell and Wilmer. And Daniel Esposito's response was not found on the CD. And this email from Jim Sinicki's legal secretary, Dawn Detgens, was found on the CD at Bates 8809, but again, the attachments were not found on the CD. This includes the draft billing statement that contains the concerns and second thoughts language. And this email in which Daniel Esposito accused Wilgraven of misappropriation, which was the first red flag email, was not found on the CD. And the email in which Daniel Esposito wrote that he was sweating like Nixon, which was the second red flag email, was also not found anywhere on the CD. These are the same two emails that Snell Wilmer attorney Michael Donahue described as very concerning, yet for some reason Snell and Wilmer failed to preserve them. Had we not discovered these emails among the digital evidence we collected, they might have never been found. I should also make clear that the CD contained more than 15,000 pages of documents. It is possible that some of the missing documents are actually on the CD, and we just haven't been able to find them. That brings us to the end of the narrated presentation. All that's left is for you to review the summary that follows, which runs for approximately 3 minutes. Thank you very much.